Good morning, everyone. Welcome to our busy day of joint judiciary. We have a lot of topics on the agenda today. We just remind everyone at these meetings, no matter how passionate we might be about different topics, to keep our discussions within the rules of decorum. Be kind to each other. We'll hear everybody that wants to speak, and we'll do our best to move through the agenda in a timely manner.
Thank you, Mr. Co-Chairman. Just for those joining us in the Zoom world and those here in person, we have definitely packed what could have been 2 meetings into 1 meeting, as the Co-Chairman appropriately alluded to. So we just really appreciate, I want to reiterate, everyone will be heard and have a chance to speak, but really appreciate if we keep our comments to the legislation when there is a bill draft. We keep it on point to the legislation that's in front of us and keep it on point to topic. And sometimes when there are a number of people lined up to testify, it's really easy to repeat testimony, but we unfortunately just don't have the time to hear repeat testimony. So if you could keep your comments fresh and new, we would really appreciate that. And then lastly, Mr. Co-Chairman, I'll just say, we do take additional testimony by email. So if you want to share something with us and you just don't have enough time based on the day and how it progresses, we certainly would love for you to email us any additional testimony that you have. Thank you, Mr. Chairman.
All right. Well, call the roll, please.
Mr. Chairman, this is for the Joint Judiciary Committee for August 12th. Senator Crago,
Excused.
Senator Crum, Senator Hicks, Senator Kolb, Representative Brady,
Here.
Representative Bratton,
Here.
Representative Chestick, Representative Filer,
Here.
Representative Kelly,
Here.
Representative Lean,
Here.
Representative Singh,
Here.
Representative Webb,
Excused.
Co-Chairman Olson,
Here.
Chairman Washit.
Present.
You have a quorum.
Thank you. Those of you who are attending, there is a sign-in sheet out in the lobby. Please make sure you get your name on there. We have minutes were sent out with your packet. Barring any objection, we'll approve those minutes. See no objection, the minutes are approved. Our first item of business this morning, Wyoming Department of Family Services. Director. Who has the bill draft? You want to walk us through the bill draft?
Yeah, I can do that, Mr. Chairman. So 26 LSO 75 draft 0.5. This is 2-01 in the online meeting materials. This is a bill draft the committee requested at its May meeting. It is based on 2025 House Bill 48 and 2025 Senate File 157. This bill draft provides a requirement for the Department of Family Services to review the effectiveness and impact of the department's programs and services, including the sharing of data for specific purposes that are expressly stated in the bill draft. So on page 2, line 10, this is a new paragraph in 9.2.2104, and it requires the director of the Department of Family Services to provide that, notwithstanding any confidentiality requirements that are specified in statute, the director is required to review the effectiveness and impacts of the department's programs and services. And this includes the sharing of data to the extent permitted by federal law, and then only for the 3 purposes that are specified on lines 15 and 16. First, referrals. Second, the provision of services. And third, participation in bona fide research. Mr. Chairman, the remaining provisions are conforming amendments to statutes that provide for the confidentiality or the protection of certain records and data, and I can run through those quickly. Page 3, line 3, this is an amendment to 14.3.214A, which concerns the confidentiality requirements of the Child Protection Act. Page 3, line 13 is a conforming amendment to the Juvenile Justice Act. Page 4, line 1 is a conforming amendment to 146306, which concerns juvenile probation. Page 4, line 13 is a new paragraph in the CHINS Act, the Children in Need of Supervision, to provide that the department may share data for those 3 specific purposes, and only a federal law permits it. Then moving on to page 5, line 1, this is 146604A, a new paragraph that allows the department to have access to the Juvenile Justice Information System, but only for those 3 purposes that were on page 2. Then on page 6, line 3, this provision in 2118-202 concerns the statewide longitudinal data system that the Community College Commission is required to provide. And this inserts the Department of Family Services as an entity that is entitled to have access to that system. Then page 6, line 11 in 352108 concerning adult protection, this is another conforming amendment. Then page 7, lines 1 and 2 is a conforming amendment in statute concerning the provision of public benefits. Page 7, line 9 requires the Department of Family Services to promulgate any rules for this act. Page 7, line 13 is a reporting requirement. So the department would be required by October 1st, 2026 to report to this committee on the types of data that are shared under this act and any safeguards that are implemented to protect personal data. The bill has a split effective date. The substantive provisions are effective on July 1, 2026, and the remainder is effective immediately. With that, Mr. Chairman, I'd be happy to answer questions.
Committee, any questions for Mr. Fuller? Vice Chair?
Yes, thank you, Mr. Co-Chairman. Mr. Fuller, in the new language on page 2, there is a list of statutes of confidentiality requirements that are basically exempted from the data sharing. Can you just briefly summarize what those are for those who are listening?
Mr. Fuller.
Yep, Mr. Chairman, Chairman Olson, those statutes that are listed on page 2, lines 11 and 12 are the statutes that are amended in this bill draft. So the outline that I just provided of those provisions beginning on page 3 through the top of page 7 are the statutes that are referenced here.
Okay, I'm tracking. Thank you.
Further questions to Mr. Fuller on the bill draft? Seeing none. Director?
Good morning, Mr. Chairman, Mr. Co-Chairman, members of the committee. My name is Corin Schmidt. I'm the Director of the Wyoming Department of Family Services. And thank you for inviting us to speak today on this bill. This is a bill that has been around actually for a few years, at least in concept. Originally under the Mental Health and Vulnerable Adult Task Force, we discussed the provisions of confidentiality in regard to the Department of Family Services. This bill then came to you all as part of a joint judiciary activity last year and then was introduced during the session. The first iteration of the bill did not make it out of House Judiciary Committee last year. It was reintroduced in the Senate. The Senate heard the bill, passed the bill. It went back to the House and then died by a tie vote in House Labor. So many of you have heard some of the components of this bill, and I appreciate the opportunity to be here again to explain why it is that this was a topic of conversation at the Mental Health and Vulnerable Adult Task Force and why it's relevant today. So a few things about this particular piece of legislation. I know that it seems a little bit lofty because of the way that our confidentiality rules and statutes are created. But essentially, the Department of Family Services engages with families who need some level of assistance. When those families come to us, whether it's because of a benefit or they come to us because somebody called us, that's the information that we have within our department. We have one particular statute that is very, very strict, and that is around our Child Protective Services information. So when we receive a call, or if we're involved with a family because of abuse, neglect, a call of juvenile delinquency, or a child in need of supervision, then that information is highly protected under the current statute. So once that information comes to us, if somebody makes a report, for example, we are not allowed to come back to any of those reporters. We are not allowed to say anything more about that case, except internally or through court proceedings. So that data then is very restrictive when it comes to working with families who do not need our level of intervention and being able to connect them with a service. So the confidentiality information the information that we have is highly protected. The statute that we have is very old, and it did not contemplate the types of services that we provide now or that we can connect families to now. In our agency, we kind of live by 3 values. One of them is children, families, vulnerable adults live safe at home, and we want them to live safe at home. We do not want those children to have to come into our care, into the state's custody, when we believe families, if given enough of the appropriate types of interventions, those children can continue to live safely with their parents, or the same with vulnerable adults who maybe need a little extra support so that they can stay in their own houses. With that, then, we have the information, the confidentiality requirements that in the 70s made a lot of sense. However, today, when we're purchasing services, those services that are available for families to be able to keep them safe at home, we want to be able to better make those connections for them. We want to be able to refer and to have those systems be able to reach out to families so that they don't have to come further into our system. So that's really an opportunity for success, which is our second value. Our third then is supporting the people who support the families. We recognize that communities, and we really appreciate that communities want to take care of their own, that families want to take care of their own, and that you don't need a state level of intervention in order to do that. But we are the ones that often hold information that would be helpful for other communities to be able to provide services like home visitation services to families who maybe need some support in parenting, in helping to adjust, and to provide education to families and taking care of young children. So the big conversation that really came out during the last couple of sessions is around this confidentiality and what kind of data we have. And the concern about that data being protected, that information being protected. And we take that very seriously. We recognize that we have information about some families that is absolutely families at their worst. We know that. That is not the type of data that we're interested in sharing. What we are more interested in being able to do is to be able, when we get a call on a family, from a family member who maybe is concerned about a grandchild, or a teacher that's concerned about a child having clothing. When we get those calls, most of the time, they do not rise to a level of our intervention. We say thank you. We ask the reporter, can you make some connections? Can you help that family? But at the end of the day, we will not get involved. However, in about half the cases, it does rise to a level where we go, well, this is something that maybe we need to look into. So when we look into it, we often find that a lot of those cases also do not rise to the level of an intervention where we knock on their door. But what we know is that those families are concerning somebody. Somebody has said, I'm worried, I'm going to call the state agency that's responsible for abuse and neglect. It's around those situations that we believe our confidentiality provisions really get in the way of being able to connect families with services that they need. We know a family needs a service. We know that there's a service that would be very much appropriate for that family. But because of the confidentiality standards right now, we cannot make a call to a service provider to say, here's a family that's come to our attention. The family does not warrant any further involvement. but we also know that they need some help. So the information that we have when we talk about all of the data really sits very much protected within our own system. And this isn't new data. We're not interested in going out and getting new data. This is data that's already in our systems, but because of the confidentiality statutes, those systems cannot talk to each other. An example of that would be with our juvenile justice information system. And that was something that this committee a few years ago had asked us to build. We built a juvenile justice information system to help communities understand how their services are affecting youth in their community. Are the services that are being provided that we purchase helping our youth to stay out of our system, out of the DFS system and potentially even the correction system? Because of our confidentiality statutes, that data information system cannot talk to the information system that we have that tells us about whether or not those kids came into our custody. So when we're trying to look longitudinal and say, wow, we have a community juvenile service board in a community that you all have funded. So the state has funded an intervention locally that is intended to support that youth and prevent them from coming further into our system. Because that system can't talk to our system, we'll never know if that was effective. And that was one of the driving forces behind the juvenile justice information system, was to take some of the community-based information and understand, did it have the intended impact as it came into the DFS system? That's another example. And the third example is just looking over time. We don't know if the services that we provide have an intended impact over time. I have spent many times explaining to various legislative members about why we don't know if a kid or if an adult in the Department of Corrections was served by us in our juvenile justice system. We don't know that. The reason why we don't know that is because we are not allowed to connect that data. So going back then to this particular bill, this bill really does limit in very specific ways what we can share, how we can share it, and with whom we can share it. And that is the provision that says the executive or the director, based on the director's approval, information shall be shared in very limited circumstances. Those circumstances are dictated by why is it that we want to share the data, not we want to share all data, but specifically what data do we want to share, for what purpose, what are the components of that data, and what will be the life cycle of that data. So in practicality, this is how it would look. We right now have an agreement with Medicaid where Medicaid can, we can share information with Medicaid and Medicaid can share information with us about children in foster care. However, most of the cases that we're involved with, children are not in foster care, they're at home, but they may be receiving Medicaid services. What we don't know is are those kids holistically getting all of the services that they may need. Our systems are separate, and we cannot connect that information for most of the cases that are in our custody or in our care. So if we were to use that example, that request would come to the director, and the director would then ask a series of questions. Who are you sharing data with? What are the data elements that you're going to share? What's the time period that you're going to share that information? Where does the data exist? What's the electronic method by which that data will get passed back and forth? And then based on that, with the director's approval, the information then will go through a rule promulgation process. And the rule promulgation process then allows the general public to speak to that request. So through the rule promulgation process, those rules are made, the comment period is open, the general public has an opportunity to comment, and then based on the comments, those rules will either be modified to address the comments, or that they will then they'll go further into the system, which that means then the legislature has an opportunity to review what it is that's being proposed, and the governor's office. So the process is very transparent. This isn't an open-ended, we want to share everything. But there are some times where we believe that the current law is so restrictive that with some permissions and a lot of safeguards that we can then move forward and look at a specific case-by-case basis and then move it through. So those are some of the generalities of the bill and what the bill does. I know we're really short on time. I have lots of examples. I could give you a lot of reasons why we think this is necessary. But at the end of the day, this really is our attempt to share data in very limited ways where we believe that overall it can help families, one, get connection to services earlier, or two, know more about how we're doing and be able then to modify our service delivery to be able to be more effective. The last thing that I want to maybe end with is that we have learned a lot about child welfare throughout the years. We've learned a lot that in those most extreme circumstances where a child is harmed, or even maybe where a child dies, through national research, what we know, the common themes in those cases, is at the very beginning, when a family was struggling, there was missed communication points between the systems. That early on, the systems weren't allowed to talk to each other, or they did not talk to each other, and then the family progressed over time without a whole lot of intervention by the systems that could help. And in those cases where we've seen extreme harm, there has been a common theme of missed opportunity. What this does is give us a little bit of a chance to connect families with the resources that they may need, resources like therapy, like counseling, like substance use treatment, like home visitation, like mentoring. It gives an opportunity for volunteers, churches, to be able to provide some support so that government doesn't have to get involved in a big way. And at the end of the day, children and families are able to stay home safely. Mr. Chairman, I'll stand for questions.
Very good. Committee, any questions for
Chair.
Director? Representative Kelly.
Thank you, Mr. Co-Chair. Thank you for being here. Looking at this bill, I see that it essentially increases the scope, the reach, and the responsibilities of the department. Now, in light of our recent session where we had a reduction of coal tax revenue, an increase in exemption for business property, and a significant property tax exemption, we're going into a budget session. We're expecting revenues to be tighter than usual. Are the department's current resources and personnel adequate to meet the needs of families right now in crisis, let alone taking on this expanded role?
Director.
Mr. Chairman, Representative Kelly, I believe that there are some places where we could be investing, providing more services, which would require more dollars for families. An example of that would be what we had asked for in our supplemental budget request last session, which was two areas. One was for adult protective services, and the funds that we receive for adult protective services right now in general funds are about $80,000 per biennium. Do I believe that's enough to address the need? No, I do not. Another place where general fund investment was around independent living services for youth who are aging out of care, meaning a child, an older youth that has spent time in foster care. We do not provide general funds for those purposes. We asked for general funds for those purposes. And what those dollars would be are independent living services. helping a youth find apartment, helping a youth to connect with economic support, job training, helping a youth to access through education, whether it be a certification or an educational component at school. So do I believe that we have enough right now to address the problems that we see with the population we serve? No, I do not.
Follow up.
Thank you, Mr. Co-Chair. So from a worst-case scenario perspective, the funding does not come through to adequately cover services, but we were to expand the role of the department at this time. Quite often, the families most in need and the adults who are most vulnerable are the least able to advocate for themselves. What assurances are there that these limited resources would get to the people who need them the most and not the people who best advocate for themselves?
Director.
Mr. Chairman, Representative Kelly, that's an interesting question because I think that's one of the reasons why we're asking for some of the flexibility in the statute, is that we recognize that, and let's take vulnerable adults as an example. We only get involved with vulnerable adults when they're vulnerable. We don't get involved with adults because they're elderly or they're developmentally disabled. We are called when there are no other methods or ways that families or communities can figure out how to help these particular clients. So they call us and ask us to intervene. And intervene in a way for vulnerable adults, which is really about service coordination. In the most of the cases that we have with vulnerable adults, it doesn't get to that extreme court point where we believe that we have to have the court intervene in order to help us. In the majority of those cases, we are looking to community supports and trying to connect that person with those community supports to address the vulnerability or the risk of vulnerability. So in that case, they a lot of times aren't advocating for themselves. And a lot of times in those situations, those adults just want to stay home. And our job then is to figure out how to help them stay home. So we do not get involved with the general public. We get involved when somebody calls us because there's a concern.
Senator Hicks.
Yeah, Mr. Chairman, back to the bill, Corin. So on page 2, when we bring in this new duties that allow the director and the department, I'm curious, as you've gone through referrals and provisions of services for adults and children, but I haven't heard any discussion about participating in bona fide research, and because the nature of you're dealing with somebody's information, now that's going to be disclosed in some type of research project. And so I'm trying to just understand the curiosity of what purposes do you need to use this data to participate in some level of research? Who's going to do the research? Who's involved in the research? What's the nature of the research? That's a pretty broad category when we just say you get to participate in research with somebody else's information. I'm a little concerned about that. So can you help
Director.
alleviate some of my concerns? And then, Mr. Chairman, I have a follow-up question too.
Director.
Mr. Chairman, Senator Hicks, it starts with then the purpose of the bona fide research would come to the director with a very specific reason for that research. So for example, with the Department of Corrections example that I gave, it would require some level of analysis to know and understand if our systems are working. In a bona fide research project, using that example, the proposal would come to the director that would outline who is going to do it, what is the purpose of it, what data are we going to be looking at, and then all of the things that you asked about. The director would then say, yes, this is something that we want to do. We would then promulgate the rules. It would go through the rest of the process. But the example is around, in our system, we may have a youth that engages with the juvenile justice system through a municipal court. And then that youth is cited in municipal court, maybe the behavior continues and they make it into a circuit court. And then that youth doesn't do well through circuit court, then they come to juvenile court. And then they may go to the boys' school. What we don't know is in the Department of Corrections, how many of their population has had previous involvement with any of those previous court systems. There has oftentimes been the question about, well, if we have youth going all the way through those systems and they end up in DOC, in the Department of Corrections, what are we missing? What were the opportunities that we would have had to intervene in a different way, perhaps? That's the kind of research that we could see being proposed. What's important about this particular request is that it wouldn't be identifiable. We would make a one-time match between the youth, the names, and then that information would be deleted, and what we would have is the data set that's not identifiable. So there won't be names in the data that's analyzed. We won't have addresses. We won't have all of that personal identifiable information because it will be cleaned out. And then what's left is that we know this line went through these number of systems and that's it. So the protections are there through the process by which the proposal comes to the director. Then that proposal then goes to the rule promulgation process, and that's where all of the protections come into play.
Yeah, and Mr. Chairman,
Mr.
just to
Co-Chair.
follow up.
Senator Hicks.
Thank you for that explanation, but it doesn't say what you just said. It just says participate. It doesn't say that you're not going to utilize that information, that individual information in there. So it puts that duty squarely back on the director or the next director, or the director after that, and that staff. And so it's overly broad in my opinion. But Mr. Chairman, I had another question as to what was the purpose, including DFS, to access the SLED system with the community colleges and the university? Because that basically just tracks students' grades and courses and that kind of information. And again, this is now we're giving you access to a whole other database that I'm trying to figure out how that ties into providing services and also vulnerable adults by getting into the SLED system. So that's a little bit concerning too. So if you can articulate why that's important, it would be helpful.
Director.
Mr. Chairman, Senator Hicks, we were invited to participate in the SLEDS system because of the SLEDS process and the SLEDS grant. So that's one of the technical reasons why we are in there. But this is a part of the bona fide research component. The SLEDS data would be a really good example of the bona fide research. We serve a lot of youth and we have no idea what their educational outcomes are. We have no idea that once a child comes into care, except from a very national level, that we know that their educational outcomes are not as good as other kids. But we don't know that from a Wyoming standard. And the SLEDS data in and of itself is more than just about grades or reporting. It is a research component that tells us about the educational attainment of youth and of adults, and what is it that they do with that educational attainment. So for example, in recent SLEDS presentation, they talked about the number of, this was around COVID a few years ago, they talked about the number of people, it's de-identified, they talked about the number of people that were accessing different types of programs at the community colleges. Nursing, and then of those nursing students or of those CNAs, how many of those were staying in Wyoming? So it is pure bona fide research. It really isn't about a grade reporting, so to speak. It's aggregate, de-identified data that tells us about what a certain population has done. So in the example, back to SLEDS and the Department of Family Services, part of their grant was looking at at-risk populations and what's the educational attainment and successes of vulnerable populations. It made sense then for them to invite us to join them in being able then to look at our specific vulnerable kids and seeing how they did as a subgroup in addition to the larger population. So it allows to stratify, but again, all de-identified.
So Director, this doesn't obligate the department to participate in any research, but it authorizes if you so choose to participate. Is that the way you read this, Bill?
Mr. Chairman, yes, that's exactly right. This just authorizes, it doesn't say you shall.
Further questions? Representative Lean.
Thank you, Mr. Chairman. Thank you for coming today. I was looking to refresh my memory. I believe during committee earlier this session, you mentioned that when an individual comes in contact with you at first, you're able to share what programs are available. Is that still the case?
Director?
Mr. Chairman, Representative Lean, yes, if the person who needs the services calls us, we can share that information.
Follow up?
Follow up?
Thank you. And so then would there be some personal accountability at this point? They have the opportunity to participate in the programs that they would know about, but if they're choosing to not participate in them, then that's their own personal accountability?
Director?
Mr. Chairman, Representative Lean, yes, if a person who is wanting services or wanting to know about services contacts us, we can make those referrals, but yes, it's up to them.
Representative?
Thank you, Mr. Chairman. Thank you for coming. So when you give the person a list of the referral services, but my understanding from our meeting in Torrington is that this would then authorize the department to then go to private providers and allow them to now contact the person. Is that correct?
Director?
Mr. Chairman, Representative Broughton, if that's the proposal that's brought forward, and that's the suggestion, then that proposal would go through the promulgation process. So this isn't a blanket, yes, now anybody can call and we can share any information. If the department makes a decision that we want to be able to connect families with mental health services, and we want to be able to call the mental health service center and ask them to reach out to the family, that would be a proposal that would come to the director, and then it would go through the process. I think it's important to remember that this isn't just we're opening it up for whatever we want to do. It is intentional and specific to basically very limited questions or very limited purposes. So if it were to go through that process, yes, then we could do that, if that is something that the agency or that is requested of us to be able to do. So this doesn't allow all the ideas that we have to come to fruition. This allows us to explore the idea, to be able to categorize exactly what we're doing, what information we would release, and then it would go forward. Then that permission would be there. But the law itself just doesn't give blanket permission.
Further questions? Senator Cole.
Yeah, thank you, Mr. Co-Chair. Director, it still doesn't go back and answer the question that I have back on page 2 on the new added language under X. What, rulemaking authority frankly scares me because I don't trust the agencies to make rules that follow statutory, intent. So anytime we talk about confidentiality, I'm wondering, to de-identify, right? I mean, this is like, if you read this, it says if it's under that section, then it's okay, right? Then you don't violate the rules. What guarantees do you have that you de-identify other than rulemaking, like through your process? And Director, I have confidence in you, but the next director, I don't know who that's going to be. Maybe it's not going to be somebody like you. So what assurances does the public have that, not through rulemaking, I don't care about rulemaking, right? I think that's frankly an easy way out that we take too often that leads into results that we complain about as legislators, right? Which is our own fault probably because we said up to rulemaking. But on your side of the equation, what guarantees do you have? Guarantees, not a rulemaking. I don't care about rulemaking. I mean, I just want to know that, I guess your opinion about where we're at with this language in this bill draft. Is this something that you can Is it in here somewhere else, buried in this language in here statutorily? Or is it only through rulemaking you're going to de-identify information of these people we're talking about, whomever they may be? That's my first question, Mr. Chair.
Director.
Mr. Chairman, Senator Kolb, the confidence, I think, in some respects, comes with the way that we do business as an agency. So we have what's set up, a process by which we are understanding and knowing what data we have, what exists, who shares it, who doesn't under current law. So this is how it looks for us right now. We have what's called a data governance committee within our own agency that documents every time that we are legitimately sharing data under current law. When we do that, we have written agreements with entities that then further show the public and further then give permissions on what explicitly can be shared. We call that a data use agreement. So some of this comes with just in general how it is that information technology has chosen to govern itself when it comes to sharing data and the information that's gathered by that technology. So in our agency, we have a committee, and when there is a proposal, for example, that we want to engage with information sharing internally, for example, then in that situation, we will have a data use agreement that is going to cover how does it get shared, when does it get shared, what is it that gets shared. So the data use agreement is what then is the public confidence that we are keeping track of the information we have, how we share it, and for what purposes. What the rule promulgation process does is it basically takes that same premise and makes it public. So the rule promulgation process is an easier way for us to take what we already do internally and getting the input of the general public, because it does go out for comment and it does come back to you for review. That is the guarantee that I can give you, and also just on the ethical and moral standards that we all have to protect that data. And our agency takes that protection very seriously. It's the work that we do. We are highly cognizant of what it can mean, and we are very careful to make sure that we are intentional about the law that allows us to share that data if we are sharing it.
Senator Kolb, you have a follow-up?
Yes, Mr. Co-Chair. Well, thank you for that answer, Director. However, it still didn't make me feel any better than I started off being concerned. The concern still is, for you, sure, you're the director and you're going to do it a certain way, but for the next director, this isn't about the director, it isn't about you. It's about the organization and transparency to the public and assurances to the public, not through the hope and will of folks that may be in your position in the future, but in fact, it's memorialized in statute. That's my concern. That's my biggest concern with this. And it still remains my biggest concern, because frankly, I really don't trust agencies, not into the future, certainly, not when I'm not here anymore. So that, and I guess the answer is I guess it has to be in statute. What's your thought on that in order to memorialize it so it doesn't change in the future with folks with good intentions? Just your opinion on that. Thank you, Mr. Chair.
Director, your response?
Mr. Chairman, Senator Kolb, I would hope that just the integrity of the work we do would bring some level of confidence that the people who get involved in this work have no interest in sharing data freely. I can't give you a personal guarantee that a future director isn't going to make a decision about what it is that they want to explore. I hear your concern about the rule promulgation process, but I do think that is a really good way for light to be shown on what it is the agency wants to do. And it's through that process, then if the future legislature has concerns, they can get involved at that point as well. That is the stopgap. If there is contemplation about some of the things we could do with this particular piece of legislation that would help with that, certainly we would be very willing to work on some modification to this statute or to this bill. I hear the concern coming from Senator Hicks. I hear your concern. And if the bona fide research component of it is causing consternation, then we are more than willing to talk about taking that out. The bill would still be fine for us if we deleted the bona fide research component. The part that we really do want to keep intact, though, are the referrals. And that is because of the information that comes to us about families in need. The majority time does not come from the family in need. It comes from a concerned community member that sees that need and is asking us to do something. We want to be able to do something at the lowest level possible.
Anyone else before we go back to Representative Lean? Second time, Representative Lean.
Thank you, Mr. Chairman. Just a quick question about notification for the research portion. Is there intent to give them any kind of notification that they're being participants in this research?
Director.
Mr. Chairman, Representative Lean, I hate to say this, but it's a big depends. It depends on what the research question is. If we are looking over the last 50 years of data, it would be impossible to inform people that that information may be then shared with educational data. If it's a very limited data set, then yes, if it's possible, if it's feasible to do, if it's practical to do, then that could be built in. So this legislation really proposes a lot of what ifs. It's a lot of scenarios. It doesn't tie directly to one specific request. It is contemplating as potential requests for information come in, does the director have flexibility to authorize it within certain parameters?
So Director, we're spending millions of dollars trying to help kids that are struggling in various crisis situations. And yet some of those kids still end up in the Department of Corrections years later, which tells me that maybe there's things we're not doing properly while we're trying to intervene in those kids' lives early on. Do you see this type of data collection and research giving us a window about what works, what doesn't work? Because right now, I think we have a curtain where this committee and the legislature in general, we lack information about program effectiveness. And we keep talking about, how do we just keep spending money, but it doesn't do any good. Well, it seems to me this bill gets at the heart of that. It helps us gain information about possible systemic failures and systemic successes, so we can replicate and enhance those things that are successful and do away with those things that are not working well. Do you agree with that overall program evaluation element?
Mr. Chairman, yes, I do agree with all of that. Wouldn't it be nice to know that if we have a population in the Department of Corrections and we were able to do some analysis about whether any of that population had had some involvement with the juvenile justice system when they were youth, and if that was in Wyoming, wouldn't that be something that we would like to know, understanding that at that point of contact with a youth in Wyoming's juvenile justice system, that maybe we could have done something differently and avoided that trajectory? Yes, but right now, it's just one person's guess.
Senator Hicks.
Yeah, Mr. Chairman, just to follow up on that, and it may just be terminology that we're struggling here. Data analysis and research, in my mind, are two completely different issues. And so get to the data, how many of this population were involved in this versus research, in my mind, those are two different issues. This is already existing data that's in the system. It's just a matter of analyzing that to make informed decisions.
Yes.
Research brings in a whole different connotation and a much broader nuance of activities that could be involved in. So I'm just wondering if we're getting hung up on verbiage and nomenclature. At least in my mind, it seems like that's a real stumbling block for me right now at this point. So
Director,
maybe we
data
need to
analysis?
massage the wording a little bit.
Could we substitute data analysis for research in this bill?
Mr. Chairman, yes. We could, that is the intent. When we say bona fide research, we were looking for a term that could capture data analysis and evaluation. That may not be the best term. It may send us down a rabbit hole that we don't want to go down. What we're really interested in is being able to evaluate the data that we have to determine whether our programs are effective, that does require a level of analysis and research. That may be interchangeable in some regard, but I think for the purposes of this conversation, the term research may send a visual image that we're really not trying to send.
Further questions? Do you wish to testify?
Thank you, Mr. Co-Chairman. No, I'm good, thanks.
Anyone else in the room wishing to testify on this topic? Anyone else on Zoom?
Mr. Chairman, we do have Ann Clement who signed up online.
You bring her in, please.
She'll be joining us in one moment.
Good morning. Please identify yourself for the record and briefly tell us what you'd like us to know.
Good morning, Mr. Chair. My name's Ann Clement. I'm the Executive Director at Wyoming 211. I was here on behalf of the Department of Family Services in case there were any questions about opportunities for a platform in which to safely share this information. We currently operate a program that is called CommuniCare. It is a community information exchange that allows creation of care coordination teams through a HIPAA-compliant environment for the purpose of sharing information. But I was just here for the purpose of answering questions if they arose. So I will, that's all that I had to offer today. Thank you.
Thank you for being here this morning. Director, any concluding comments?
Yes, Mr. Chairman, and thank you for being willing to hear this bill again. I know it is a tricky piece of legislation. I recognize that. And when we were discussing it at the Mental Health and Vulnerable Adult Task Force, we recognized that this is a very sensitive area. And as a result, we tried to build some guardrails around it. To Senator Kolb's point, it may not be the best guardrail, but through the rule promulgation, giving it some light where the general public could speak to it, we thought was also helpful. Something to consider as we think about this legislation, in the Juvenile Justice Information Statute, there are some provisions written that say, to Senator Hicks's point, the department may by rule promulgate a process in which, when a subject reaches the age of majority, all information in the Juvenile Justice Information System pertaining to that subject can be preserved in a manner to avoid identification of an individual subject while still allowing for longitudinal data and analysis of recidivism. So I just bring that to your attention that there have been times where we've been able to write into legislation some provisions that protect confidentiality. So we may want to look to the Juvenile Justice Information System Act, which is what this committee did a few years ago, as a place for reorientation. We are fine with not having bona fide research. That was just a term of art that was suggested that we could use to maybe try to capture what we were after. If data analysis and some sort of evaluation language is better, we are fully comfortable with that as well.
Very good. Committee, you have a motion? Senator Craigle, move the bill draft. Representative Craigo seconds that. Discussion on the bill. Yeah, proposed amendment, Senator Hicks.
Well, Mr. Chairman, I've been playing with this, and so I do think just looking at the definition between research and analysis is a much more, so maybe we just say, strike the word bona fide research and participate in analysis of existing data within the department or other agencies or something to that effect. I don't have the exact verbiage at this point in time.
Okay, something along the lines of data analysis and program evaluation. Are we good on generally what we're talking about here, replacing kind of a conceptual amendment to replace the idea of bona fide research with program evaluation and data analysis? Everybody clear? All in favor of that amendment, say aye.
Aye.
Those opposed, no. That amendment carries. Further amendments? Senator Kolb.
Mr. Chairman, I would like to just throw
Senator
out.
Kolb.
Oh, Cole.
Thank you, Mr. Chairman. Just an overarching concern that I still have about sharing data. That I realize it's nuanced position that we have to share data within the department for the purposes of conducting their business. But sharing data beyond their department to anyone else, I think it's, in my mind, mandatory that we memorialize this with that, memorialize the fact that no identifiable data can be associated with that subject. And I realize I hadn't had time to work the language at all, but I still concerned that, and you reinforce my concerns about the statement about your rules. Okay, great, you have a rule. Based on what? You know, based on your current position. So I think I think what, in my opinion, what killed this thing last time was this, what we're talking about now, about identifiable data, when it's associated with a client or a situation beyond the department. So sharing any data beyond that the department's normal current practices, to any outside agencies has to be data wiped when it comes to unidentifiable features that's associated with that data beyond what you're currently doing. So I don't want to restrict what you're doing now, I think, but I want to memorialize the fact that we cannot have any identifiable features with a client or a situation that goes off and goes into the world of the internet, let's say. And that's my concern. I'm sorry, I don't have language that effectively would encompass this, but I think it's worthy of a discussion for an amendment, and I'd like to propose that amendment, maybe with the help of the LSO to help me craft the language.
Do you have enough to work with there, Mr. Fuller?
So, Mr. Chairman, perhaps my suggestion on page 2, line 16, after, at the end of that sentence, add a new sentence that reads something to the effect of, data shared under this paragraph shall be shared or transferred in a form that is not individually identifiable.
And that's exactly what I meant to say, Mr. Chairman.
Do you have a second to that amendment?
Second.
Second by Senator Crum. Discussion? Representative Bratton.
Thank you, Mr. Chairman. So my concern is with how does that mesh with the three primary purposes of this bill, the first one of which is the referrals. And you said that the referrals are what you care about. And I have privacy concerns about those referrals because you're referring individual families to outside agencies and now letting them contact the families. That's not protecting people's privacy.
Director.
Mr. Chairman, Representative Broughton, the referrals that we receive aren't coming from families, usually themselves. If they need a service, they'll walk through the door. We have the opportunity to talk to them. about what it is that we have and making those connections. Where the referral services comes to is, for example, we have a school that calls us with a concern about a family. So the family doesn't know that the school has called, but the school is a mandatory reporter under law. So they are going to call us and say, we have concerns. At the same time, we have maybe a pastor who's a mandatory reporter. That pastor is calling us and saying that they have concerns about a family. We have information from two different sources about the same family that have the same, that are expressing the same issues. We cannot say to that pastor, we know of this family, we would love for you to be able to reach out to them and make a connection with them. What we say is thank you. Same thing with the school. So now we have two sources of information about a particular family that we now know needs services. It doesn't raise to the level where we're going to give them a call. But yet, we know that if the school and the pastor could maybe work with that family, then that family would have a better shot of staying at home or have a better chance at being successful with their family. It's that kind of referral for services that we would be interested in. In that particular situation, what we would like to do is say, yes, we know of this family. We think they need some assistance. Would you please reach out to them? Because they've already come in contact with them. Do they need to know that that DFS was the reason why they're reaching out to them? No. But they're on our radar, and we have the information nobody else does, but people want to help. It's in those limited situations where we would like to be able to say, please reach out to them, please make a connection, because we won't. We will not do anything with that information that has come in from that, on that family, from that pastor, because it doesn't rise to the level. I think a different way of saying this, and it's complicated because of all of the various ways that information can come to us, that families come to our attention, and trying to be able to adopt a general process that lets connections and communities happen to the benefit of that family without our intervention. But a lot of times, we're the only ones that know that that family is potentially, could potentially benefit from a particular service, but we can't reach out and connect that service to that family. I can tell by your face that that didn't make any sense.
So, committee, we can move this bill, we can make a final decision on this bill draft today. We can carry it over for our next meeting in Cheyenne for a final look at it, perhaps with the amendments that have been brought forth and voted on this morning. In the interest of time, my suggestion would be that we don't take final action on this bill draft today, bring it back to Cheyenne, and maybe in the time between now and then, committee members, the department, others may come up with verbiage that might be beneficial to tweak the bill draft in a way that makes us more comfortable with it. Senator Hicks, I see a hand wave there.
Yeah, Mr. Chairman, I do think this needs a little more work. I do have another proposed amendment.
Please bring that amendment now, please.
So,
You're still on an amendment.
We shall have another amendment?
do we,
we
yeah,
still-
You have Kolb's amendment in front of you right now.
Okay, so we have Kolb's amendment still pending? You want to remind us, remind the chairman here what that amendment was specific to?
Yep, so Mr. Chairman, the idea of the amendment was to say that no identifiable data associated with this data should be shared.
Further discussion on that amendment? Okay, all in favor of that amendment, say aye. Aye. Those opposed, no? No. Show of hands, those in favor? 1, 2, 3, 4. Those opposed? That amendment has failed. Further amendment, Senator Hicks?
Yeah, Mr. Chairman, it gets back to the section on page 5 where we bring in 21-18-202, which is the community college commission and the sharing of the SLEDS data. I think back to the explanation of the director, that inclusion was specifically for the purposes of research. Again, if you read what the SLEDS data is, even in that, it's for common transferring process system to use by a common course numbering for all undergraduate programs at community colleges and universities. I just don't think we need to include this in there. And so, Mr. Chairman, I think it's superfluous to what the primary objective is to get the vulnerable adults and children in need. And so, again, I don't want to expand this back to Representative Kelly's into another large duty and kind of a thing that the department's responsible for. So I would just move that we strike all of 21-18-202 from the bill.
Every second on that amendment? I don't see a second. Second for Representative Lean. Discussion on the amendment? Anybody? Don't see any discussion. All those in favor of the amendment, say aye.
Aye.
Those opposed, no? No. That amendment has failed. Further amendments? Okay. What's the pleasure of the committee on the bill for today? We're going to vote on the bill draft, bring it back in Cheyenne? Any preference?
Mr. Chairman, we'll just follow the lead of the chairman.
Okay. Mr. Co-Chairman, my recommendation is we just bring it back in Cheyenne and finish it there.
Yeah, I think that's fine. Probably just procedurally have Senator Crago and Representative Chestick modify their motion or rescind their motion, rather.
So the original motion was to move the bill. Senator Crago?
Mr. Chairman, I guess there were several motions made after that which amended the bill, so I don't know what it does to those. I think you have the prerogative to table that. Whether or not I do anything on my motion, I think the motion would still be sitting there when we bring it back in Cheyenne. I believe that's how that would work.
All right, with that, we'll bring the bill back in Cheyenne and take care of it then. Okay. Director, thank you.
Thank you.
That brings us just a few minutes late to mineral interest and ownership. We have a bill draft, but I think there's some comments that we want to hear before we dive into the bill draft. Good morning, Mr. Detai.
Good morning, Chairman Washut, members of the committee, Travis Detai with the Wyoming Mining Association. Again, really appreciate the committee's time in hearing this bill. I'll give you, I'm joined here by Joe Sylvester. He is the Natural Resource Manager for WyoBen, one of our large bentonite producers in the northwest corner of the state, who's been doing a lot of the legwork on this issue and this bill for us. And I'll just kind of give you a little update of what we've done since the draft bill came out. We have met with other stakeholders, Stock Growers Association, Farm Bureau, the Bankers Association, Petroleum Association, to discuss the draft bill. And there are a lot of some concerns out there, and I think, we've touched a third rail in Wyoming politics when you deal with split estate and the lawyers start coming out of the woodwork and some other folks. And I will just say that we've heard some of the concerns and we've worked to address some of those things. And I'd like to turn it over to Mr. Sylvester, but with the intention, I think, Mr. Chairman, there's a lot of work that needs to be done on this bill, and it does need a little bit more time, but I'd like, to turn it over to Mr. Sylvester, kind of let you know where we're at, and I think there's some other stakeholders that would like to speak on this issue as well. And in the interest of time, I'll just turn it over to Joe right now.
Mr. Becker.
Good morning.
Good morning, Chairman and committee. Thank you all for the time, being able to continue this conversation, the discussion. Introduce yourself. My name is Joe Sylvester. Sorry, this is new. I am the resource managers as well as the government affairs manager for Wild Bend. We have 4 manufacturing mining facilities in northwest Wyoming. We also have packaging in Montana as well as Toronto, Canada, for our company. This came to my attention as I was working on some title search and looking for this for dormant, abandoned mineral, not active, not people that have active interest, active leases, active mortgages against this property. And so that's where this was born, is looking at the abandoned and looking at the non-use of the actual resources that are out there. Within the bill, as Travis mentioned, we have reached out to the various organizations as well as to the title companies. We've reached out to the Wyoming Association of Professional Landmen, the Wyoming Land and Mineral Association, Wyoming Land Title Association, asking for their participation in this too. At this point in time, we've not heard from them. We have had a webinar last Friday on this topic and had members joining us to have this discussion and continue it on. The bill looked like it was pretty much cut from North Dakota, and there are some things that was brought to our attention in these meetings and as well as prior conversations that we probably need to tweak within that to make it within the state of Wyoming statutes and making sure notification, timing, what type of property, what type of minerals actually are that we're talking about here in the case. State of Wyoming currently, as you all know, we currently have on books the definition of what abandonment and non-use is in different areas. If you own a rental property, which I used to in Grable, I had someone just pack their suitcase and left everything in their house. Well, it went to storage for quite a while until I was able to get rid of it. But there is statutes out there for that. There are statutes for unclaimed property by businesses, stocks, insurance, money, anything that way, escrow accounts, and where that money's got to go to the unclaimed services for the state of Wyoming, as well as the abandoned vehicle Wyoming statute that's out there. So this is nothing new. Abandoned rights in different areas. It's not a new topic. It's just we have decided, state of Wyoming has not decided to at least address this until today. And so we encourage the continued discussion on this, but a couple of the tweaks that we would like to recommend. Would you like to go into that, Chairman?
I'm not sure it's terribly productive this morning, but if you wish to, go ahead.
I think, Mr. Co-Chairman, what my understanding is of the stakeholders is that between that, right now, we just want to take some general testimony, and then between now and the next meeting, we'll put together a working group that can go through all of those changes and try to find consensus on the bill in the interest of time, if that works for you.
Mr. Chairman, I think that works for us, and I think we would be comfortable putting off the bill. And I would like to volunteer, the Mining Association to coordinate a working group to spend the time that's needed on this issue, because there are a lot of moving parts. It is a heavy lift, and, we don't do these things because they're easy. We do them because they're hard, and we want to get a final product. And again, to reiterate, testimony from the previous committee, this is nothing we want to ram through a rush. We want to take the time to do this right, to bring everybody to the table. And again, I would volunteer to coordinate a working group with the stakeholders and with members of this committee to make sure we get it right and get and bring a good solid bill at the appropriate time.
Are there members of the committee interested in serving on? Senator Craigo? Others? Senator Hicks, Senator Kolb, any House members? I'll volunteer. Okay. Representative Singh and Representative Shestak.
Couple more and we'll have the whole committee on.
We have the whole committee on the working group, yeah. No, we're good, we're good. That's
And
fine.
Mr. Chairman, I might have to have someone send me those names so I know I don't have a pen or a paper with me.
We'll be happy to communicate. Yeah.
Thank you, Mr. Chairman.
Others in the room that would just want to offer some general comments about this topic today? Representative Shestak, question?
I do have a question of the intent of the bill. It seemed like there's at least two different problems that I'm not sure which the intent is to address. Is the intent of this bill to address simply a way to essentially quiet title or to settle a title of claims that you can't identify who they belong to? People, these interests get fractured and sent and descend through different processes, and you don't know who owns the interest. Is that the intent? Or is it the intent, if I know I have an interest, but I just haven't used it for a period of time, are you intending to preclude that known interest that has been just not used for a long time? Does that make sense?
Whichever of you wish to grab the intent.
Yes, Chairman and Representative Shestak, the intent is to look for the abandoned minerals and have a mechanism put in place which is a little bit easier than quiet title or what's the other one, the airship that is out there as well. This gives the layman opportunity to be able to just take a notice and be able to take it and follow a process to get the minerals transferred over to them on abandoned property. We have multiple properties that we have abandoned interest in Wyoming and in Montana, where I went to the families and said, you own 2% of this. And they said, we have no interest in this. We're not going to go through probate. And so those are just dead out there. I'd rather have the surface owner be able to take that for the opportunity as it comes in. The second component of this would be providing notification of record. Currently in our courthouse records, we do not have any way to record where the mineral ownership is unless something is declared out there. And great-great-grandfather may have said, I reserve 50% of these. Well, you don't know where it went, as we're now working in the fourth generation and where those minerals are, because there was no money coming from that. That topic has just gone away from everybody, and it didn't actually transfer from family members generation to generation. So they've got to go back, resurrect, and figure out who the true owners are and pay in order to have that done in a situation that we're working on. And of that one, we have 52 that we believe could potentially be mineral owners. We've had 3 people that actually signed the lease so far, which is a minority of the interest. And the others, we've had multiple say it's not worth our time, our effort, because there's not that much royalty out there that they will receive compensation, or their time's more valuable to deal with other things.
That's sufficient, okay? Yes, Senator Hicks.
On page 2, it brings in mineral interest, and it means interest whether created or assigned, blah, blah, but it lists gravel and coal, and so automatically I see a giant conflict here, because particularly with these, so it's the surface owner and the subsurface is what we're talking about, but in some cases, you have to surface mine, let's say gravel, and so how do the other states handle these issues with these abandonments from a standpoint that the only way to get at these minerals is through surface mining, but yet there's an abandonment there and somebody else is going to acquire that? So how do they identify that and address that issue?
Sir.
Chairman, Senator Hicks, gravel is the first thing on my list of things that we need to tweak because in the state of Wyoming, gravel is a surface interest unless it's severed as part of the mineral estate. So first of all, to strike it is our recommendation out of the bill and separate that. When you talk about surface mining, the company I work for is a bentonite mining company, and we are a surface operator also. Our bentonite is not part of the surface estate unless it's a whole piece of property. And so there is a difference between surface rights and subsurface rights, mineral owners. And so, yes, we would request gravel be struck from this.
Representative Brad.
Mr. Chairman and Senator Hicks, the draft bill came from North Dakota, and we think that that was just part of what was in the North Dakota statute that got added in. And so one of the many tweaks that we've kind of come across.
Thank you, Mr. Chairman. Thank you for coming. I have a question on page 3, let's see, line 20, about operations. Operations being conducted at the place where the mineral interest is located for injection, withdrawal, storage, or disposal of water, gas, or other fluid substances. So this looks like it gets into pore space. Does carbon dioxide storage harm a mineral right? And can you discuss things surrounding that?
Mr. Detail?
Yeah, Mr. Chairman, I think this is one of the other issues that came right out of North Dakota that would probably have to be addressed and Wyomingized. And I don't think pore space is in our intent on this.
All right.
So I don't think, do we want to get into the bill draft in detail today? That'll be the role of the working group. So further general question, Representative Lean?
Thank you, Mr. Chairman. My general question for this and for the working group would be something to consider when you gave the examples about abandoned vehicles and such, abandoned property, the state takes control of that and then the state either auctions it or sells it, or the municipality or the sheriff's department, those kind of things. So my question would be, why does the ownership go to the landowner or the surface owner and not to the state?
Mr. Detail or Stephen?
We were just looking at different states that seem to have something that's been enforceable. To marry that back up to the surface owner seemed like the right place. You could write whatever you want. And so if you want to go to the state or to the counties, in the state of Montana, Carbon County did capture on one of my leases a 7.25% mineral interest, and we are dealing with Carbon County for an open active mine that we currently have. So the page is blank at this point in time. We're proposing that it goes to the surface.
Okay. With that, anyone else in the room wishing to speak generally to this topic? Please come forward. Please introduce yourselves and briefly, might encourage, briefly tell us what we need to know at this stage.
Mr. Chairman, committee, good morning. I'm Tracy Good. I'm the Natrona County Clerk, and this might be a moot point at this time, but as the clerks are referenced only in the recording capacity of this bill, we do have a difference in terminology used in the bill between filed and recorded. That is throughout this bill. Filed and recorded are two separate processes in our setting. Filed basically means you put the document in a folder, and recording means receiving a document, giving it a receiving number, date and time stamping it, and then indexing it into our public records system. So as we read the bill, we believe the intent is for all the documents to be publicly available, and as such, all documents should be recorded. For clarity, we would respectfully request the committee have conforming language throughout the bill that would strike any reference to filing and instead replace with the word recording. Those, I have, a list of those areas, but I think that could probably be addressed at a later time. Also, we have a couple of amendments that we would like to offer, but again, we would be willing to offer those at a later date if that's the wish of the committee. Thank you.
So can we list you as one of the stakeholders?
Mr. Chairman, absolutely.
All right, thank you much. Mr. McGagnon.
Thank you, Mr. Chairman. Jim McGagnon with the Wyoming Stockgrowers Association. Just want to briefly point out that while this initiative came from the mining industry, this is an issue of direct interest to surface owners in the state as well. And if you look back, most of the parcels that involve these split mineral interests were lands that were homesteaded over 100, 150 years ago, and the minerals were an integral part of the surface in that homesteading. And then a couple of things have happened. As families split out and you try to keep one family member running the ranching operation or the farming operation, another way to take care of some other members is to give them an interest in the minerals, and those have split over many generations. In other cases, it was always quite popular to, if you sold the surface estate, to keep the mineral interest in the hope that that's where your wealth was going to come from some point in the future. Some cases it did, and many others it did not. But this is an important issue to us. We're pleased to see it addressed. We're happy to participate in the process. I had offered a few amendments to the previous speakers. I won't get into those today, and a couple of other things that do need to be addressed that as this goes forward, but we think this can be beneficial to the surface owners as well to get this straightened out. So they, at least whether or not they choose to opt to try to force abandonment and acquire those interests, at least it would be helpful to them in learning who perhaps holds those interests, and if that can even be determined. So we think there's a lot of opportunity here. Just in response to question that was asked earlier, why to the surface owner rather than to the state? I think that one of the justifications for that is that that's where those originated. They were held by a surface owner at some point in time in nearly every case. The other thing is that because split estate is always a challenge for us, to the extent that this can help us to reduce the amount of split estate in some instances, that can also just benefit the state by facilitating the management of our resources, both surface and subsurface. With that, Mr. Chairman, I would be happy to take any questions.
Thank you. Don't see any. Appreciate you both this morning. Anyone else in the room wishing to offer comment on this topic? All right, with that, I'll close public comment.
Online.
Oh, we went online. Very good. Who's online?
Yep, Mr. Chairman, we have Mr. Moline online.
Good morning. I'm sorry I missed you up there. Please introduce yourself formally for the record and briefly tell us what you'd like us to hear this morning.
Thank you, Mr. Chairman. Brett Moline, Wyoming Farm Bureau Federation. Strongly urging this committee to take this topic forward. It is, as been outlined by the other speakers, it's extremely important to every industry that uses natural resources in Wyoming. So encouraging you to take it forward and volunteering to be on the work group. I would take any questions you or the committee may have, sir.
Questions, Mr. Moline? Don't see any this morning. Thank you for joining us.
Thank you.
Anyone else? Okay, with that, I'll close public comment. We have a working group. My notes show Senator Hicks, Senator Crago, Senator Kolb, Representative Singh, and Representative Chestick will be the working group. Sounds like you have lots of stakeholders who are interested in participating. So hopefully you have an update for us in Cheyenne. Okay. With that, let's take about 10 minutes. Committee, take a quick break, and we'll come back at 9:37. Welcome back, everyone. Just a reminder to get close to the microphones. They work better when we're a little closer to the microphone than if we're too far back in terms of the YouTube broadcast, so please take that into account. Our next topic, retail theft issues. We have a bill draft. Who's going to walk us through the bill draft? Mr. Fuller?
Yep, Mr. Chairman, 26 LSO 81, draft 0.4. This is 4-01 in the online meeting materials. This is a bill draft that the committee requested in May and is based on 2025 House Bill 187. This bill would amend the penalty for the criminal offense of theft, amend the monetary threshold to trigger a felony theft offense, and amend the number of theft offenses, regardless of degree, that are needed for a theft offense to qualify as a felony theft offense. So on page 2, lines 7 and 8, this concerns the offense of felony theft, and it amends that monetary threshold to trigger a felony from $1,000 to $500. Then page 2, line 12, this concerns misdemeanor theft. This change changes the penalty of misdemeanor theft from 6 months and a $750 fine to up to 1 year and up to a $1,500 fine. Lines 16 and 17 changes the property value threshold from $1,000 to $500. This is a conforming amendment to the felony change that's on page 2, line 7. And then on page 2, line 19, this changes the cumulative threshold for felony theft from the 5th offense to the 3rd offense being necessary to trigger that felony. Then on page 3, line 13, this is an amendment to 63411E concerning the unlawful use of theft detection shielding devices. This, similar to the change to misdemeanor theft, amends that penalty from 6 months imprisonment and $750 fine to up to 1 year of imprisonment and up to $1,500 fine. The staff comment on page 3 just notes, just provides for the committee's reference the subsections A through D of 63411 that are referenced on page 3, line 11. Those are just for the committee's reference. This would be effective July 1st, 2026, and happy to answer any questions.
Thank you, Mr. Fuller. Committee, any questions? Senator Hicks?
Mr. Chairman, I just asked staff, Mr. Fuller, do we have anything else in statutes that sets the level for felony at a $500 level? Is there anything comparable that you're aware of?
Mr. Fuller.
Mr. Chairman, Senator Hicks, I would have to look. I know there are other statutes that do set a monetary threshold, property destruction, for example, being one. I can take a quick look, though.
So, Mr. Chairman, the rationale for that is just try to keep our statutes uniform when we start dealing with felony level penalties instead of having monetary limits all over the place. I think that creates long-term conflict and difficulty. So
thank you.
If we're going to amend this, maybe we need to look at these other ones, or we just leave this exactly where it's at to be consistent with the other statutes.
Mr. Fuller, on the 1 year, $1,500 fine, is that consistent with municipal court maximums? Are they still at 6 months, $750? I just want to make sure that if we make this change, do we force all these theft crimes to be prosecuted in circuit court?
So Mr. Chairman, that change was not enacted. I believe the committee and the legislature considered a bill concerning that. For municipal court, that penalty is still, I believe, the 6 months and $750. And then, Mr. Chairman, to Senator Hicks's question, I did take a quick look, and it doesn't appear, at least in the criminal code, that there's another monetary threshold at $500. Yep, Mr. Chairman, there is not, to my quick search. Yep.
Representative Justic.
Thank you, Mr. Chairman. Mr. Fuller, could you just remind me what problem we're trying to solve here? What is the reason for changing the breakdown between felonies and misdemeanors, lowering it to 500 instead of 1,000? What's the reason?
Mr. Fuller.
Mr. Chairman, Representative Chestik, I believe there are speakers who will come after me who would be able to better explain that.
further questions on the bill draft for Mr. Fuller? Seeing none. So we've got a list of witnesses. Mr. Steenbergen? Good to see you again. Get close to the microphone, state your name for the record, and then let us know if this bill draft is anything close to what you were hoping this committee might do.
Dale Steenbergen. I am President CEO of the Greater Cheyenne Chamber of Commerce. I am also CEO of the Wyoming Chamber of Commerce. We also run the Wyoming Retail Association in our office. Mr. Chairman, our members are both from retail and chambers across this state are very thankful for this bill being moved forward. Retail theft is something that has been climbing significantly in this state. And frankly, our law enforcement needs some bigger tools, or at least they indicate to us locally in Cheyenne that they do some bigger tools to deal with this. These folks get caught doing this again and again. They've been very smart about coming in and stealing just under the value. They do it multiple times, and they just kind of walk away. I'll never forget, this was, and we did some work on these statutes maybe 4 years ago. And I'll never forget the lady from Riverton who owned a meat market, and she'd been sacked out again and again and again, and $990 because it was 1,000. And so I think our members are pretty tough on crime, and they think anything that we can do to give opportunities for law enforcement to be able to start cracking down on this and get it out of our state is a positive thing. So we appreciate the committee drafting the bill, and we like it.
Thank you. Appreciate that. Mr. Thompson?
Well, thank you, Mr. Chairman. My name is Alan Thompson. I'm the Executive Director of WASCOP, the Wyoming Association of Sheriffs and Chiefs of Police. Been talking to our members a little bit since the last meeting, but then this bill draft hasn't been out really long, so I haven't gotten input from across the state. But some of the things that I'm hearing from our membership is that the component of this bill that raises the length of jail time and the fine amount would be more in line with what we would hope to be discouraging or be able to put people out of circulation for a little while based on these crimes. The value part of it, I think, is a policy decision on your part and the greater legislature's part, but there is very differing numbers throughout various different statutes. The property destruction threshold for eluding is $10,000. And we don't have a threshold for accident reporting dollar amount damages anymore. So we just know that thresholds, while consistency does seem to be something that would be wanted, there already is inconsistency amongst various statutes. So once again, that's a policy decision on your part. And I would also say that just like our previous speaker up here, when you have a $500 impact versus a $1,000 impact on a small struggling business in a small community, I do think that $500 does matter a lot. But I would leave that up to those business owners to talk to you about what that impact means. And I'd be happy to answer any questions if you have any, Mr. Chairman.
Mr. Co-Chairman.
Thank you. Mr. Thompson, so a few years ago, the legislature actually had dealt with the consideration of adjusting this threshold, and it's a very tricky part of the statute to get right because you can capture a really wide net by just dropping it to 500. So example, and I just want to make sure that this is part of it would be in line with your intent of amending the statute. But so if a kid steals a cell phone, he or she is going to become a felon now because any cell phone is, maybe you could find plenty of phones under 1,000, but at the 500 level, unless it's Senator Barlow's flip phone, it's going to result in a felony. And I just wonder if we're casting the net too wide and we're going to capture scenarios like that. And maybe the justice system, through the judge, et cetera, and the prosecutorial discretion can handle a lot of that. I don't know, but just wanted to hear your thoughts on it.
Mr. Thompson.
Thank you, Mr. Chairman. I do want to clarify that our organization didn't bring this idea. We're just here to offer some input on implementation of it. Once again, this is a policy decision on your part. But there's a couple of things. So your prosecutors, law enforcement has discretion in those cases, and so does the prosecutor. So just because the threshold is $500 and the phone was worth $750, that doesn't mean that the officers and the prosecutor can't charge that as a misdemeanor. There's still that discretion involved in it. And also the value of an item is, in my understanding and application, it's not the value of it when it was brand new, it's the value of it when the theft occurs. So in the store, that phone's worth $750. Once it's spent a day in the hands of a 15-year-old at high school, the resale value of that might be about $100. So all of those things are subject to how the committee decides to proceed with this bill, but we're good with either of those. Other than we do think that the penalty provision being raised would be something that might be beneficial from a law enforcement standpoint.
Representative Lean and then Representative Kelly.
Thank you, Mr. Chairman. Thank you for joining us today, Mr. Thompson. My question is, if we reduce the crime value, would your partners anticipate then smaller thefts along the way versus individuals, like they're coming in now at $900, say they come in at $450, would we then be prosecuting just smaller thefts?
Mr. Thompson.
Yeah, Mr. Chairman, I believe that in my experience, especially organized entities that understand the law and do make a living out of this, I believe that the value amount of each individual case will go down to try and stay under that $500 threshold. But then there is still the component of opportunistic thefts and people that aren't aware of the change in statute. So I would guess that organized side of it would adjust relatively quickly, and the rest of them might take a while to catch up.
Representative Kelly.
Thank you, Mr. Chairman. Just to clarify, organized retail theft is often a multi-state operation. It's actually organized theft. It's the position of law enforcement that you've spoken to that this would serve as somewhat of an effective deterrent from targeting Wyoming stores. Are we to understand here that organized retail theft would actually be up to date on statutes?
Mr. Chairman, I'm not sure I have the complete answer to that. We hope that it would. I don't know. Reducing the threshold might have an impact on the dollar amount, and increasing the penalty might be able to put people out of circulation for a while with a jail term or an increased fine amount. I think that when you're looking at organized retail theft, that third strike felony is the biggest component of this statute that would impact retail theft as opposed to the other changes in here.
So, Chairman, really quickly, so just basically, we'd expect them to learn the hard way about the statute then?
Yes, Mr. Chairman, that's a good summation, yes.
Further question? Senator Kolb.
Yeah, thank you, Mr. Chairman. A question about organized theft. Do we have any definitions that allow prosecutors, to your knowledge, to charge with organized theft as a separate element of a crime instead of an individual? I mean, we're talking about individuals here, right? And if you do it, times it turns to a felony. But what about organized? Have we ever tried to get our arms around that so we can define it kind of like, gang-related or some such other terminology? But what's your thoughts on that?
Mr. Thompson.
Thank you, Mr. Chairman. There's been a lot of conversations about that. I think I think one of the tools that exist in statute right now are the conspiracy statutes. You very seldom see those charged in general crimes. They're usually related to drug crimes. I would defer to the prosecutors on that. Law enforcement will look at a case individually and see if they can tie it to other ones, the aggregation of the crime. So if you have, for instance, here in town, you go from one store to another across town and you steal $100 worth of items. If we can aggregate that into one continuous conduct throughout could even be an extended time period, you can put that aggregate together over $1,000 and make it a felony in that series of misdemeanor crimes.
Follow up.
Senator Cole.
Yeah, thank you. Let me try this again, because I obviously missed the mark here. I'm talking about particularly a situation where there's more than one individual working as a group of criminals, coming in, say, 2, 3, 4, or 5, whatever be the case, going into a retail establishment and then stealing from said retail establishment as an organized group, where they have lookouts and, they have a whole plan on how to do this. In that vein, what are your thoughts on trying to get our arms around that type of level of criminality? Thank you, Mr. Chair.
Mr. Thompson, how would conspiracy work in a case like that, or is there other options?
Mr. Chairman, I wasn't prepared to testify about conspiracy today, but my recollection is 2 or more persons engage in a pattern of conduct and take a substantial step towards completing that illegal activity. And that's, in my experience, a difficult case to prove and investigate. Whereas when the theft occurs, the low-hanging fruit are the theft and the shoplifting component of it. There's aiding and abetting. There's these other crimes that happen. But I think what the senator is asking for is how do we get to that point where we have good, solid laws that discourage that group criminal element that oftentimes comes from out of state to prey on Wyoming. And those are conversations that we've been having a lot. We haven't proposed to bring any language to that right now, because as you bring new language, then you have these conversations about the 15-year-old kid that steals an item and now is facing the penalty that was designed for, retail theft, organized retail theft issues. So the retail industry might be the best people to talk to on that, but law enforcement has a few tools available right now, but the theft itself individually is kind of the low-hanging fruit on that.
Senator Hicks.
Yeah, a real question when it gets to lowering the felony penalty from $1,000 to $500. Do we have any idea, looking back at this historical data, how many people that would have captured? And just for the committee's edification, the reason I ask that question is I want to know what the cost of the state is associated with incarceration in one of our institutions versus a higher penalty for a fine or something like that. Do we have that data, and do we know what that looks like? Because it becomes a budgetary issue for our appropriations committee and the Department of Corrections if this is substantially going to increase the prison population. So what's that look like historically?
Mr. Thompson.
Mr. Chairman, I don't have any numbers on that. It's my experience, if the threshold would change, many people would avoid that threshold knowing the difference between a misdemeanor and a felony. They do that right now. People intentionally steal less than $1,000 so that they stay in that misdemeanor realm. So I would guess that if it dropped down to 500, a vast number of those people that are in the business of stealing would pay attention to this law and keep those individual thefts under 500.
All right. Anyone else in the room wishing to testify? Mr. Moser?
Question, Mr.
Oh, we have another question. Representative Brady.
Thank you. Thank you, Chairman. Thank you, Mr. Thompson, for coming today. I have a question. This bill talks about a person, and I know we're talking about, and then there's conversation about organized groups and things, but here's my question. If it were a person and 3 strikes to make it a felony, would it be 3 separate locations? Does it have to be 3 times at one location? Is that specific?
Mr. Thompson?
So, Mr. Chairman, in the third, fourth, fifth offense, like DUIs and other laws, it's always been my impression that for prosecution purposes, you have to have, in this case, if the law were changed to the third offense would be a felony, you would have to have 2 previous convictions of a law similar to theft or shoplifting. So that could be a municipal charge in Kemmerer, state charge in Billings, Montana, and then now we're in Casper, Wyoming, and this third lifetime offense of a misdemeanor theft could be charged as a felony at that point. The difference, I would think, is if you went across the town of Casper today and hit 10 stores for $99 each, the aggregate of those crimes makes one instance unless you charge them individually and got a conviction for those individually. I would guess that an offense in that series could be charged as a felony, but I don't think that's the intent of the law.
But aggregation isn't part of this bill draft.
I'm sorry. Yes, Mr. Chairman.
Just so we're clear. Further questions, Ms. Thompson? All right, Mr. Moser, do we have anybody on Zoom for this bill?
Yeah, stay up here. Because I'm not very bright. I can use all help I can get.
Mr. Chairman, members of the committee, Mike Mosier, Wyoming State Liquor Association. We support this legislation. I'll get into some reasons. I will not repeat my testimony from last time we were here because I'm painful enough to listen to once, and so I'll keep it to the bill proper. This has been an ongoing process in advancing issues involving retail theft. Remember, and I'll get into that a little bit more, this is a deterrent. The primary job of any good law is a deterrent. One of the most important things to us or to our members, now bear in mind, part of the reason this is so important to my people is because we sell a product that's really easy to resell. If you go into a retail store and steal a polo shirt or a pair of jammies, you're not going to be able to sell it down the street. However, if it's a carton of Marlboros or a handle of Pendleton, you can find a buyer pretty easily. So theft factor is quite high in our industry. The felony upgrade, I mean, admittedly, lowering the threshold is a great deterrent, but our problem is repeat offenders. In certain communities where you have the same person coming in over and over, you bust them 2 or 3 times, and they keep going in. And so moving that down to 3, and we saw that as Mr. Thompson brought up, we've seen that with DUIs. We lowered that threshold as well. People do pay attention to what it takes to upgrade to a felony. One of the things I want to bring up is remember that we're not talking about just quiet little people committing theft. We're often talking about people that are violent, people that have weapons, people that are dangerous, people you can't stop. And so that's part of the reason these deterrents are so important. Representative Kelly, and I believe Senator Kolb and Senator Hicks brought up the idea of organized retail crime. You don't learn the hard way because you know what the penalties are. And those organized retail crime theft rings know what the penalties are in each state, what the threshold is in each state, and they target those states with a higher threshold for misdemeanors and a higher number of theft convictions to become a felony. Those people watch those penalties. They know them better than we do. And so passing legislation like this, it's not busting people, it's keeping people from doing it in the first place or coming into our state. Admittedly, there are specific statutes in some states that address organized retail crime. Apologies to scripture, basically it says wherever 2 or more of you gathered for a common cause, it's a bigger crime. However, without that, I think these penalties will make a significant difference in organized retail crime from coming out of state. Admittedly, that 18-year-old stealing a cell phone, if he does it once, sure, the judge will cut him some slack. But if he does it 3 times, we got an issue here. And that's where I think the escalation to a felony is so vitally important in getting this problem under control. As I mentioned, this isn't just a casual issue to our members. It's threatening their existence and their livelihood, their employees. And as I mentioned, the violent factor, shoplifting used to be a more passive activity. It is not so passive anymore. Stopping people from shoplifting can have very bad consequences. And so anything we can do to deter that activity, and I think this bill is a great step in the right direction, I think we should take that opportunity. And with that, I'll take any questions.
Mr. Chairman?
One moment, I'm going to jump in here real quick. You bring up, Mr. Mosier, the selling of the product after the theft. And we don't get after that piece of this in this legislation. We heard some testimony about that in May. The fences, the businessman who might be buying this product through the back door and then reselling it, or people selling it on online auction sites or garage sales or however else. Any suggestions on the back end, on the fencing side, on the buying of the stolen properties and these organized theft rings? How are other states getting at that side of this problem?
Mr. Chairman, and looks like Mr. Thompson's looking something up, so I'll take this for the start. The problem is with our product is you don't need to put it online. You can sell it down the street unless it's I think we all saw a story about a multi-$1,000 bottle of scotch that was taken from a place up in Jackson. Those you would sell online, but most of the products, if you steal a carton of cigarettes, you don't need to put it online. You just sell it down the street. And so with products, as I mentioned, a pair of jammies or a polo shirt, yeah, you'd probably put it online. But what thieves tend to target is stuff that's easy to resell that you can get gratification immediately, and that's usually drugs, pharmaceutical drugs, alcohol, and tobacco. Those are your big targets just because they've got intrinsic street value that you can get money for immediately.
Mr. Thompson?
Mr. Chairman, you know, the existing laws for possessing and selling of stolen property are, I mean, usually involved in the bigger cases. So when we're looking at retail theft ring, we're catching them on the front end. If we do get that case, we're catching them on the front end. The resale of it isn't often led within the state of Wyoming. So that kind of puts us on the front end of investigating and trying to interrupt these cases. When we do have those possession or selling of, disposing of stolen property, a lot of times those are involved with in-state cases where there's, you know, like oil field equipment, or wire, those types of things, and aren't quite the retail theft rings. Both equally important components, but one that I hadn't discussed with our membership prior to today.
Senator Hicks.
Yeah, Mr. Chairman, just a question in here, because the discussion that we're having deals with, and it gets back to a little bit of the direction that Senator called us, so organized retail theft, and then retail theft, but the statute that we're working on is just theft. And so we haven't partitioned those three or those activities out, so, and I understand that I'd love to just drop the hammer on organized retail theft. I mean, these penalties are not steep enough for that occurrences. What I am cognizant of the fact that we're just dealing with theft. And so my concern is we're going to have a whole bunch of youth around the state of Wyoming by the time they graduate could potentially have felony charges against them. And so in the broad scope of the nature here, while we're focused on this retail and this criminal element, we're capturing a whole bunch of people with this statute that are probably under the age of 21 that did something really stupid that are now going to be felonies. And I'm concerned about that we're using a very broad statute to try to address a very serious problem, which is retail theft and criminal organizations. That we're going to capture a whole bunch of people with this statute that I don't think is the intent of this committee. Maybe it is. Maybe we want to throw all these 17 and 18-year-olds in prison and let Director Shannon deal with them back there and Appropriations Committee. But Mr. Chairman, I'm concerned with that. I'd just like to get the perspective of both the wise cop and then, if that's your intent, is to capture these other folks within this theft amendment? Or are we truly just focused on that criminal element and that retail component that's organized?
Mr. Thompson, we know this isn't your bill, but if you want to
Very
respond.
good. Thank you, Mr. Chairman. I think the information I'm trying to bring to you is that law enforcement in Wyoming wants to do what it can to help the lives of people in Wyoming. And increasing felony charges on teenagers is not part of that conversation. No. But in any law change, we have to look at the law that we're dealing with here. And shoplifting was carved out several years ago and added to the general theft statute. So there's not an easy mechanism to differentiate between shoplifting or retail theft and regular larceny that we used to have in statute. I do think that, once again, it's a policy decision of the legislature, but there's also that discretion on prosecution and what is appropriate. And hopefully we have, hope's not a plan, I understand, but I feel like our law enforcement and prosecutors in the state of Wyoming would charge appropriately in cases across Wyoming.
So, Mr. Thompson, can you tell us a little bit about, so if we had a property crime, you don't have to charge those kids into adult court. We could take them into juvenile court, correct? And we also have 301 deferred prosecutions. We also have, just a variety of ways of dealing with those teenagers who make a stupid mistake. Could you elaborate a little bit on the different mechanisms that might be used for a teenager who steals a $550 lawnmower or something?
Yeah, Mr. Chairman, thank you. The 301 that you mentioned is a deferment process. It's used on various laws, but the person goes through a probationary period, and upon completion of that, then the outcome is like they were never convicted of the crime. There's also prosecutorial and officer discretion. The officer does not have to make the arrest for a felony. He can write a ticket for a misdemeanor, even though the value of the property happened to be $550. And likewise, the prosecutor can reduce charges from a felony to a misdemeanor and charge based on the circumstances around the case as a whole. And I think they would look very different at something that appears to be part of an organized group when there was a distraction that was involved in the theft action and we eventually caught the person, as opposed to a one-off theft of an item. But I will also say that in my career, I investigated several juveniles under the age of 18 that were involved in strings of burglaries and thefts that impacted the community extensively. And we're charged with felonies, and I don't know of a juvenile that's gone to the prison system under the age of 18 for felony property crimes. Those are usually related to interpersonal human violence. But shortly after turning 18 and staying on that path of activity, have ended up in prison for strings of property crimes like this.
Representative Webb.
Thank you, Mr. Chairman. My question, Mr. Chairman, is do you or Mr. Mosier or Mr. Thompson or anybody else know what the thresholds are in neighboring states that we could look at?
Mr. Fuller, do you have that?
Mr. Chairman, I can take a quick stab. I know they range from $200 being the lowest, I think that's New Jersey, to $2,500. I don't recall which state is $2,500. I know Colorado is $2,000. I think New Mexico is $500. I'd have to do a little more digging to give you more specifics than that.
Thank you. Mr. Mosier, do you happen to know?
From my experience in Colorado, managing corporate retail, it was $750 then, so unless they changed it, and I think that's more the norm. So at $2,000, I can't imagine what it would be like. So it might be worth a survey. In addressing Senator Hicks' good question, that's where the multiple offenses come in. Because if you're developing a pattern of theft, by the time you're 18 or 19 or 20, you've got a dangerous issue. And that's part of the reason that multiple penalties are so important for us.
Okay. Nothing further. Thank you, gentlemen. Are there others wishing to testify on this bill? Anybody on Zoom? Anybody else in the room? Okay, we're going to close public testimony. Committee, what's your preference? Moved by Representative Singh, second by Representative Kelly. Discussion on the bill? Representative Singh.
Thank you, Mr. Chairman. After that discussion, and this is just where I'm at, if $500 worth of property is being stolen from a vendor, even if it's compact in something like a cell phone or a bottle of liquor, I don't think the size of, the valued item should be what we're looking at as a judgment call as to whether or not we apply the felony, right? So even though small things can come in $500 packages, I don't think that negates the importance of getting something like this across the finish line.
Any amendments? Any proposed amendments?
Mr. Chairman?
Representative Hicks, Senator Hicks.
Yeah. Either one works. Just hate to offend my
Senator
House
Hicks.
colleagues. Anyway, Mr. Chairman, it's been $1,000 for a long time for the felony charges. And quite frankly, I'm very comfortable with all the other escalations when we get into the multiple misdemeanors and the misdemeanor increasing to 1 year and 15. I'd rather financially keep these people working, and we penalize them through short-term jail time and monetary financial. But for the first-time offender of theft, and assuming he's 18 in 1 day, he's still an adult and be charged. And quite frankly, I think the legislature, it is a policy decision. But if we go to page 2, line 7, I think we ought to reinsert the $1,000, and then the rest of the bill, I'm absolutely comfortable with. But I'm really concerned with lowering the first time down to $500 for the unintended consequences of capturing a lot of young people for doing stupid stuff. One time.
So the motion is to remove the language that decreases the dollar amount to $500, take that out and leave the value, the threshold at 1,000. Is that the motion?
Correct.
Is there a second to that motion? Second by Senator Crago. Discussion on the motion. Senator Cole.
Yeah, thank you, Mr. Chairman. I'd just like to point out that $1,000 isn't what it used to be. With our hyperinflation we've had, I could easily argue it's below 500 in real dollars from when we last discussed, this statutory change happened last time. So $1,000 really isn't that much anymore. Unfortunately, it doesn't really buy you a lot. Thank you, Mr. Chairman.
Further discussion. Senator Crago.
Thank you, Mr. Chairman. And just, I'm sure Mr. Fuller will catch this, but it will also have to change it on line 16 and 17. It's in 2 places within the bill draft.
Got that, Mr. Fuller? Okay. So Representative Lean.
Thank you, Mr. Chairman. Just a question for the committee while we're considering this amendment. Is there another manner by which you could deter if we don't lower the dollar amount?
I think there's probably a couple of things we could probably do. The aggregating was brought up a couple times, of aggregating the dollar amounts. If you have a continuing series of crimes, somebody goes from one store to the next, to the next, to the next, and they're stealing just under the threshold. If we could aggregate all of those together into one dollar amount, we do that with certain other crimes, Mr. Fuller?
So, Mr. Chairman, this is a theft statute. In 63402H, aggregation is already present. It provides that the amount of property involved in violations committed to pursuant to a common scheme or the same transaction, whether the property is taken from the same or different persons, may be aggregated in determining the value of the property. So, Mr. Chairman, that is already included in the theft statute.
Senator Craigo.
Thank you, Mr. Chairman. I was just going to add, so on line 19, we're changing it from a fifth to a third. In a couple years.
I think the motion on the floor right now is the 500 to 1,000 issue. We'll come back to that one, to the three, unless it's relevant to the.
I was just
to the motion.
answering Representative Lean's question.
Okay, please continue.
If I can. That's the biggest deterrent in the bill, in my opinion, is changing the fifth to a third. So a few years ago, we actually passed this part of the bill, or this part of the statute, and created that crime so that it created a felony upon a fifth. Originally, I think the bill was a third, and it got changed through, in fact, I think it got changed on the floor because I don't think it was gonna pass if we didn't change it to a fifth versus a third. But I think that will have a huge effect. I think that's, I think we had two speakers that said that's the biggest part of the bill, the part of the bill that will do the most good, because people will know if we get caught a third time, it's a felony, regardless of the amount. And so I think that, just to answer your question, I think that's going to be super helpful if we're able to get the bill across the finish line.
Thank you, Senator Hicks.
Mr. Chairman, again, to answer Representative Lean's question, the other thing we could do is to follow up to increase the deterrent under the misdemeanor. We've increased it from $750 to $1,500. We could very easily go to $2,500 or $3,000 monetary penalty under a misdemeanor as a minimum too, which adds a significant deterrent, particularly for the population that I'm concerned with is youth. It don't take very long for somebody to get hit with a $2,000 or $2,500 payment to get that information out to that younger population out there that this is really, really expensive to do something stupid.
I'm going to be opposed to this motion primarily because not that many years ago, the threshold was only $100 in Wyoming. And then we raised it to $500, and then it got raised to $1,000. So I think at $1,000, especially in many of these retail businesses where they're operating on a pretty tight margin, and if somebody steals a $1,000 or $990 item off of their shelf, that's a lot of days of productive sales that they have to make up because of one theft. And so the good senator's correct, with inflation, a $1,000 item isn't much of an item sometimes, right? But on the flip side, for the retailer, for the person who's the victim of that theft, if you steal my $990 cell phone and I've got to go replace it, I got to come up with $990. And from the victim's perspective, I think that's real important. So my 2 cents, I'll be opposed to the amendment. Further discussion on the amendment? Seeing none. So the amendment is to do away with the reduction of the threshold from 1,000 to 500. Everybody clear on what we're voting on? All in favor of the amendment, say aye.
Aye.
Those opposed, no? No. I think that passed. Show of hands, all those in favor of the amendment? We got 1, 2, 3, 4, 5. Those opposed? My hearing, it did not pass, so that motion failed. Further amendments to the bill? Seeing none? So the motion is for this to become a committee bill. All those in favor, say aye.
Mr. Chairman, this would require a roll call.
Roll call, very good, thank you.
And Mr. Chairman, just by way of reminder, the committee adopted rules that require a majority of each house voting separately to sponsor a bill as a committee bill.
All right, so we'll do a roll call vote. Thank you for keeping me on track.
Mr. Chairman, this is a roll call vote for 26 LSO 81, theft amendments. Senator Craigo? Senator Crum. Senator Hicks.
No.
Senator Kolb. Representative Brady.
Aye.
Representative Bratton.
Aye.
Representative Chestick.
Aye.
Representative Filer.
Aye.
Representative Kelly.
Aye.
Representative Lean.
Aye.
Representative Singh.
Aye.
Representative Webb.
Aye.
Co-Chairman Olson.
No.
Chairman Washit.
Aye.
So, Mr. Chairman. There we go. Mr. Chairman, that motion fails by vote of the Senate.
Mr. Chairman.
Senator Hicks.
Mr. Chairman, I would move for immediate reconsideration of the proposed amendment to the bill by the committee associated with leaving the $1,000 threshold available, if that motion's in order.
Is there a second to that motion for reconsideration? All those in favor of reconsideration of the failed amendment, say aye.
Aye.
Aye. Those opposed, no. So we're going to reconsider the Hicks amendment, which is to keep the threshold at $1,000. Further discussion on that amendment? All those in favor say aye.
Aye.
Aye. Those opposed, no. The motion is now passed.
Mr. Chairman, I move for immediate reconsideration on sponsorship of the bill.
Motion to reconsider on the bill. Is there a second?
Second.
Second on the reconsideration. All those in favor of reconsideration of the failed motion, say aye.
So, Mr. Chairman, this vote to reconsider would similarly need to be a roll call vote.
Be a roll call vote.
Mr. Chairman, this is for the reconsideration of 26 LSO 81 theft amendments as amended. Senator Crago. Aye. Senator Crum.
Aye.
Senator Hicks.
Aye.
Senator Kolb.
Aye.
Representative Brady.
No.
Representative Bratton.
Aye.
Representative Chestick.
Aye.
Representative Filer.
Aye.
Representative Kelly.
Aye.
Representative Lean.
Aye.
Representative Singh.
Aye.
Representative Webb.
Aye.
Co-Chairman Olson.
Aye.
Chairman Washit.
Aye. So the committee's voted to reconsider. Do we have another motion on what to do with this? Do we use this as the original motion?
It's sponsored.
So the sponsors are still good with the motion to pass the bill as a committee bill?
Oh, you're done. You just did that.
Was that the reconsideration vote, or was that the? That was the sponsorship vote, and that passed. Very good. So we're. We have another bill draft, Mr. Fuller.
Okay, Mr. Chairman, 26 LSO 82 draft 0.5 absconding for criminal purposes, criminal offense. This is a bill draft the committee requested in May, based primarily on Mr. Chairman, your direction and discussion. This bill draft would establish a new criminal offense of absconding for criminal purposes. So this creates, beginning on page 1, line 9, a new section of statute, and it provides that a person is guilty of absconding for criminal purposes if the person first absconds, and this kind of branches out a bit. So on page 2, line 1, first you have to abscond from one county to another county in Wyoming. The first staff comment just notes that the term absconds is not defined. A court would use a plain language interpretation or plain language meaning to interpret that term, so I included a general dictionary definition of abscond. So the person would need to abscond from one county to another in Wyoming after, and then now we're on page 2, line 17, after having committed any criminal offense under this title, under Title VI, the Criminal Code, or the Wyoming Controlled Substances Act of 1971. The staff comment there just suggests, potentially another addition to that to include another element of this part with the intent to elude law enforcement. So that's the language included in the staff comment on the bottom of page 2. Then page 3, abscond from one county or another with the intent to commit an additional criminal offense under this title of the Controlled Substances Act after having committed an offense in the original county. Third, to dispose of or conceal the proceeds, property, or other items of value obtained after committing any criminal offense under Title VI or the Controlled Substances Act, or fourth, in furtherance of any felony offense. So, Mr. Chairman, the way this is set up is you have to move from one county to another, you have to abscond, and then meet one of those 4 points that are A, B, C, or D on page 2 and then the top of page 3. The staff comment on page 3 just notes that the committee may wish to include some sort of temporal element associated with the absconding. So for example, absconding not later than X time after having committed an offense to avoid, say, a long duration between the actions. Page 3, line 26 would provide a penalty, a felony, making this a felony offense punishable by up to 5 years of imprisonment, a fine of up to $5,000, or both. It would be effective July 1, 2026. Mr. Chairman, I'm happy to answer questions.
Okay, questions for Mr. Fuller? Senator Hicks?
Mr. Chairman, just for my edification, as maybe somebody that practices in this area can just articulate why we can't prosecute when somebody moves from county to county for an offense that happened in one county. I'm just trying to understand the necessity of where the deficiency in the statutes is that if you abscond that you can't be prosecuted. And maybe I'm not understanding, but just a little more background information would help me, Mr. Chairman.
So I think what we're getting at with this bill draft is not that we couldn't prosecute them for some crime already, but that the added complexity of the investigation and the likelihood that evidence or stolen property could be disposed of by fleeing from one county to the next. And I think, you know, when we talked about this in May, part of the discussion was, you know, these criminals who move from one county to the next, they may live in my city and then they go someplace else to commit a crime, then they come home and they sell the stolen property here. So the stolen property is less likely to perhaps be identified because it's being sold someplace distant. Adds complexity to law enforcement. If the suspect is now in a distant part of the state, those sorts of things. So it's a complicating factor. Not necessarily that we couldn't prosecute them. You know, if they commit a burglary or a theft in Casper and go to Cheyenne, if we can catch them and identify them, we can still prosecute them. But the likelihood that evidence might be destroyed or the stolen property gets sold through a fence or somebody on the street corner in another community and the case can't be solved. So it gets at the idea of having a tool to try to get these folks who try to move their criminal activity from one place to the next.
Thank you.
Mr. Co-Chairman.
Mr. Co-Chair.
Thank you. Just a question for Mr. Fuller on the drafting of it. I'm not sure, I don't recall a discussion of looking at other states. I'm not sure where this draft initially came from, but my question centers around the definition of absconds. I mean, that's the meat of the bill. It's the crime is absconding. So is there an advantage to not defining it? I'm just confused as to why that's not initially defined in the draft, or if that's because of the language we looked at from somewhere else didn't define it, or help me understand that.
Mr. Fuller.
Mr. Chairman, Chairman Olson, I think when it comes particularly to criminal statutes, I mean, the definition of criminal offenses is up to the legislature to decide. You know, I stuck just with the plain language as a starting point. You know, I think there are other places in statute where, you know, plain language meanings, for example, burglary, you know, we don't define the term enter for purposes of that statute. A court's going to use the plain language meaning of that term. That was the thought process there. Mr. Chairman, I had a hard time finding another state that had a similar, you know, concept to this. I think the closest would be probably some sort of robbery or theft under the Hobbs Act, under federal law, where there's that interstate commerce component where items are moved from one state to another in the commission of that offense.
So we're free to add a definition if you wish. All right. Anyone wishing to testify on this bill draft? Mr. Steenberger.
Mr. Chairman, Committee, Dale Steenbergen again. So I was educated in Oklahoma, so abscond is a mighty big word for me. But I do think this tries to start getting at some of the things that we are very concerned about, right? The fencing, if I'm concealing the product, transporting it somewhere else and selling it and trying to hide that. So there's a lot, I think it's complicated. I'm not an attorney, so I don't understand all that, but I think we are trying to get to that organized kind of idea where I have, take it somewhere else, I get it sold. The one question I had, and maybe that Hobbs Act was the reason for that, but it said in Wyoming, and a lot of our stuff that gets, a lot of our retail organized theft seems to be, it jumps down into Colorado, or it jumps into Nebraska, or it jumps into South Dakota or up to Montana. So I think I would like to see something to that, but the idea of a add-on for, you know, the teenager, Ian, taking it 3 counties over and putting it with a fence and have a sophisticated way to conceal that. So we're continually concerned about that too. I know some of my retail members is that the goal is not to go after some, you know, grandma who steals a pint of vodka. But if we can figure out a way to throw the hammer down a little harder on these guys that have these extra steps built in, that would be great. And this seems to do that, although I think it would take an attorney's mind to clearly delineate that. Thank you, Mr. Chair.
Questions for Mr. Steenberger? Thank you very much. Mr. Correnti.
Thank you, Mr. Chairman. Joey Correnti. I'll be just testifying as me today. Looking over the bill, the term absconds, I think it could simply be just changed to traveling because of the way it's laid out, just traveling across county lines after this has already happened. And then further in the bill, it's laid out for these purposes. Anytime you cross a county line, it's just traveling. And that's focusing on what the bill's talking about. Not the crime, not the selling. You're doing it crossing the line. It would probably require a catch title change. But also, I was listening to the conversation earlier about criminal organized activity, criminal gang activity. There is definition in 6-1-104, specifically criminal street gang under Romanet 14, and then the pattern of street gang activity, which requires collectively organization, association, or group of 5 or more persons committing 2 separate crimes within a 3-year period. So I think we could consider some of that language and also saying, hey, we just passed a bill draft out of this committee that reduced it from 5 crimes to 3 for a felony. Maybe looking at that definition of the criminal organization from 5 persons to 3, just as a definition change, and then applying it to this language saying anytime you have more than 3 people and they do this theft and they cross county lines, it's really capturing that larger group with focus. Specifically on page 3, line 6, when you travel across a county line to dispose of or conceal the proceeds, property, or other items of value, I'd like to possibly hear some contemplation on adding the words retain possession of. So to dispose of, retain possession of, or conceal. Because I'm a little concerned, and this I know, and I did look it up, is covered in other crimes, but specifically traveling across county lines in this bill and saying, well, I stole it and I meant to use it for myself, could be loopholed out of prosecution or conviction, or at least a reference to the other statute that recognizes theft for the purposes of retention for personal use. Other than that, again, the contemplation of the time period, since we already have a definition for criminal organizations and gangs, I would say anytime somebody crosses a county line after or to commit a crime in the last 3 years, because it's already in there under the pattern of criminal street gang activity law. So if we had to put a time frame on it, that's where I would start, because we already have that language. And with that, I will stand for any questions.
Questions, Mr. Correnti? Representative Brad.
Thank you, Mr. Chairman. Thank you, Mr. Correnti. What was the statute again that you referenced?
The definitions in Title VI is under 6-1-104. These criminal street gang or criminal organizations pattern of criminal acts is under Romanet 14 and 15, I believe.
Thank you.
And it does include reference to theft, vandalism, destruction of property. All those crimes are covered by that definition.
Thank you.
Mr. Fuller, to that question about retaining for their personal use, does the idea of the property leaving the county help with the conceal, or is the movement of the stolen property from one county to the other concealing of that property from ready detection, or is it captured perhaps under subsection D in furtherance of any felony? So do we need, to the point, do we need to add additional information about keeping the property for personal use, or is it captured by some of the other language?
So, Mr. Chairman, two thoughts. First, to directly answer your question, an argument could be made that conceal and retain could be two different things. Mr. Chairman, at least when it pertains to theft, the theft statute, when the legislature consolidated theft into a single offense, part of that did include the concept of retaining that property, the wrongful retention of property that were the proceeds of the theft, whether committed by that person or otherwise. So that is at least covered in the theft offense. And then, Mr. Chairman, just another note about the definition of street gang and pattern of gang activity. Those definitions, as far as I can tell, are only used in a single statute in the criminal code. It's 62403, which is the offense of intimidation and furtherance of the interests of a criminal street gang. So that, just wanted to highlight that that's where that offense, that definition would apply.
Thank you. Further questions? Appreciate you being here, Mr.
Mr. Co-Chairman, I just wanted to note that, just so Mr. Correnti doesn't get credit for this, for being inside of our heads, Senator Craigo and I were discussing changing absconds to travel as well. So I think that was a really good catch by Mr. Correnti, but I'm not going to let him take credit.
Mr. Thompson?
Thank you, Mr. Chairman. Alan Thompson, Wascott, Wyoming Association of Sheriffs and Chiefs of Police. Our membership hasn't responded back on one way or the other on this concept, but I did want to point out on page 2, when someone absconds from one county to another county in Wyoming, that's only 35% of the counties in Wyoming. 65% of our counties border another state. And while I know we don't have jurisdiction in another state once they get there, having a felony charge that we can bring them back to our county and put that into NCIC rather than a misdemeanor charge that you're not going to probably get much cooperation outside of the state might be something to consider. I think if they abscond out of state, I think that it also gets at the heart of what this bill was intended to. And I'd be happy to answer any questions, Mr. Chairman.
Mr. Thompson, do you know how the U.S. Attorney's Office handles these interstates? Is there a dollar threshold before they're interested? If somebody steals a $2,000 item and takes it out of state, is that likely to be prosecuted by the U.S. Attorney's Office? Yeah.
Mr. Chairman, I feel like each time I've talked to someone about the threshold, it's changed, but it is very substantial. Tens, if not hundreds of thousands of dollars in thresholds before federal law enforcement will investigate and prosecute on the interstate level. So I mean, there's a whole other concept here. It'll just muddy the waters with the UFAP warrants, but.
Short answer is no, not likely to be prosecuted by the
yes.
U.S. Attorney's Office.
Thank you, Mr. Chairman. Yes.
Further questions? Senator Representative Shestak.
Thank you, Mr. Chairman. Mr. Thompson, so if we add interstate travel, somebody absconds interstate, but we still catch him here in Wyoming, we can prosecute him for traveling across the state line when he comes back, right?
Mr. Thompson.
Mr. Chairman, if someone absconds out of state, I believe that we could get a warrant issued for them under this statute and bring them back to Wyoming. I don't believe that the return of them to the community meets the threshold of the statute, or bringing them back against their will under arrest violates the statute. I think that it's just the issuance of the warrant and getting the other state to enforce that warrant, or if they voluntarily come back to our community and we catch them and charge them with the crime, also doesn't violate this statute.
Further questions? Ms. Thompson? Thank you very much for being here. Anyone else wishing to testify on this bill draft? Anyone online? Okay, going to close public comment. Committee, your preference on this bill?
Move the bill.
Moved by Senator Hicks, second.
Second.
Second by Representative Singh. Amendments. Senator Craigo? No? Senator, by co-chairman, amendment? I saw you talking about that, so Senator Craigo.
Mr. Chairman, I'm happy to bring the one amendment, which is on page 2, line 1, change the word absconds to travels, and I'm happy to give the credit to someone else. So that would be the amendment, and then I have some discussion after that.
So motion by Senator Craigo, second by the co-chairman. Discussion, Senator Hicks.
Mr. Chairman, just to make sure that and I didn't catch all of that, but I'm assuming that's a universal change because you got to do that in the catch title. And on page 1, line 11, the person is guilty of traveling for criminal purposes. So that it's not, or is it just?
Senator Craigo.
Mr. Chairman, I would leave that. I would not change it anywhere except on page 2, line 1, because abscond would have a legal, essentially, we're defining absconding by saying traveling across state lines.
Okay.
Becomes absconding.
Right. Thank you, Mr. Chairman.
You clear on the amendment, Mr. Fuller? Okay. Representative Shestak.
Thank you, Mr. Chairman. I'm opposed to the amendment. I have no problem with the plain language definition of what abscond means. The plain language definition includes an intent element that traveling does not, and therefore I would prefer to stay with the term absconds.
Further discussion on the motion. Representative Lean.
Just a question for the bringer of the amendment, or maybe LSO. Do we need to clarify when we say travel intrastate and interstate, or just the word travel covers both?
Anyone?
Mr. Chairman.
Mr. Co-Chairman, so that's a separate, I think that's a separate discussion. The change would only apply to county, so it would only apply inside the state of Wyoming. If you wanted to make it intrastate, that would require an additional amendment.
Okay. Everybody clear on this amendment? We're changing on page 2, line 1, the word absconds to travel. Very clear? Okay, all in favor of that amendment, say aye. Aye. Those opposed, no. No. That amendment is carried. Further amendment, Senator Hicks.
Mr. Chairman, to get to Representative Lane's inquiry, I think what we would do there, and this is a proposed amendment on page 2, line 3, bring in a new Romanet number 2 and say another state or jurisdiction outside of Wyoming.
Is there a second to that motion? Second by Representative Lean, or Representative Singh. I'm just wondering if we could just strike the words "in Wyoming" on page 2, line 2. So if you abscond by traveling from one county to another, does that by itself work without,
Yeah, or.
just by
Romanet-
taking out Wyoming? Just say,
Yeah.
because you leave, your county and you go across into Colorado, you've moved from one county to another.
Yeah, and Mr. Chairman, and I think if we do that, what we want to do is just to another jurisdiction. The point being is we have territories. So think Washington DC, Puerto Rico, these are territories of the United States. So you certainly don't want to exclude those, and then could always abscond to across the Canadian border or to another state. You could still pursue a warrant to bring them back to.
So restate your language again.
So, Mr. Chairman, if you just want to do it really simply, you could do a Romanet 2 into any other jurisdiction.
So would that include moving from one municipality to another?
Mr. Co-Chairman, I don't think you need a new Romanet. You can just say absconds from one county to another county in Wyoming, comma, or to another jurisdiction, or to any jurisdiction.
And to get, Mr. Chairman, to get back to your point, if we don't want to include moving from a county, or you could still put outside of the state of Wyoming, any jurisdiction outside of the state of Wyoming.
Another jurisdiction outside of Wyoming.
Yeah, and just leave the counties in there, or.
County, or
any jurisdiction outside of.
any other jurisdiction outside of Wyoming. You got that, Mr. Fuller? Second, agreeable to that? Okay, so how do you read it, Mr. Fuller?
So, Mr. Chairman, my suggestion would be from one county to another county in Wyoming, or from one county to another jurisdiction outside of Wyoming.
Any discussion? Ready to vote? All those in favor of the amendment, say aye. Aye. Those opposed, no. That amendment is carried. Further amendments? Seeing none. Go ahead, Senator Crago.
Discussion, Mr. Chairman?
Please.
So I just wanted to point out, as this bill is currently drafted, there's no threshold within the bill draft. So in theory, you can steal a $5 bottle of soda in Casper, drive to Douglas, and we've just made that a felony. And I don't think that's our intent. I don't think that's anybody's intent, but as I read the bill, that's what I think we've done. That we can ask LSO, we can ask Mr. Fuller, but after having committed any criminal offense, that's a misdemeanor or felony. And so I think we might need to do a little bit more work on this bill before we set it up for final passage. I will be a no until we're able to clarify some of that, because we just voted to keep it at $1,000 on the previous bill draft, and now we're making it literally $1 could be a felony offense by traveling across county lines or state line.
Okay, I think that's fair comment. Let's hold the bill for the October meeting. Members, think about further amendments that you might want to bring forward to further improve this bill draft for the October meeting.
Well, Mr. Co-Chairman.
Mr. Co-Chairman.
Give some direction to Mr. Fuller to distinguish between a felony and a misdemeanor.
We could certainly do that. Could you come up with some language to massage it so that this absconding, traveling across county lines would only apply to felony offenses?
So, Mr. Chairman, if that is the intent, that one has to commit a felony before absconding, I can incorporate that into the bill draft.
That might be too.
Senator Crago.
Mr. Chairman, I agree. The co-chairman just said that might be too restrictive, and I think that's also the case. I mean, I think what we were trying to do originally was cover a situation where someone is committing misdemeanor theft, but doing it in an organized fashion and continuing to drive across county lines to, fence the product. I don't know what the sweet spot is. I do not know that, but I know it's not $1, but it may not be $1,000 either, which would create the felony you know, we probably don't need this if it's, if we're, you know, we're moving from 1,000 down to 500, it becomes a lot easier. I don't know the right answer. I just know it's not in the current bill draft.
All right, so let's not take action on this today. We'll bring it back in October and massage it further to see if we can make it work to our satisfaction.
Mr. Chairman,
Senator Hicks?
just a request, and so
We can maybe put an invite out to at least the Laramie County DA and see if he might join us on,
Or we could issue a subpoena.
well, we could do that, but that's not our style.
All right.
All right. All right. Oop. Gets us through retail theft issues and brings us to our 10:50, so we're 8 minutes late on Wyoming Judicial Branch. Wyoming Judicial Branch. We have a bill draft, 26 LSO 0077.5. Mr. Fuller, you want to walk us through that?
Yep, and Mr. Chairman, this is 5-01 in the online meeting materials. This is a bill draft the committee requested in May and would propose an amendment to the Wyoming Constitution to require that persons selected for the office of Wyoming Supreme Court Justice must be confirmed by the Wyoming Senate. The operative language begins right at the bottom of page 2 and then the top of page 3. And so in Article 5, Section 4B of the Constitution, it would add a sentence to provide that a person appointed by the governor or the chief justice to the office of justice of the Supreme Court under this subsection shall be confirmed by the Senate before assuming the office. The staff comment just notes that if this amendment were adopted, then 28-12-101 through 28-12-103 would likely apply. I included those as a separate attachment. That's 5-02 in the meeting materials. And the committee may wish to consider, it doesn't necessarily have to be today or even this year, but the committee may wish to consider whether any changes to those statutes may be necessary if this proposed amendment were adopted. One example, Mr. Chairman, is those statutes talk about the term of a person expiring upon the expiration of the governor's term. The Constitution spells out the terms of Supreme Court justices, so that's one place, one example where those statutes would need attention. Mr. Chairman, page 3, line 23 is just a ballot statement that explains what the proposed amendment would do, and I'd be happy to answer any questions.
Questions for Mr. Fuller? Okay. Is there anyone in the room wishing to testify on this bill draft? Maybe we just do, everybody can come up, but we'll just take testimony a little bit at a time here. Introduce yourself and tell us what you'd like us to hear. Keep in mind, we're trying to avoid redundant testimony and keep it brief so we can stay on track today.
Good morning, Chairman. My name is Ross Strickman, citizen in Casper. The genius of our constitutional system is the balance of power and the tension between the various branches, which is a healthy tension. I am in support of this legislation for a number of reasons. From time to time, it does make sense for the legislative branch to look at that balance and determine if there's any adjustments to be made. In this case, this would give the opportunity for the people's elected officials, the senators, to question nominees and question them not on how they would determine a decision on a particular case, but questions such as how they see the text of the laws and the Constitution, how they interpret them, what their view is of standing, which is an issue that comes up quite a bit, how they feel about recusal in certain situations. So I am in support of this legislation.
Thank you, Mr. Schiffman. Any questions? Appreciate you being here this morning. Good morning.
Good morning, Mr. Chairman and Mr. Co-Chairman, members of the Joint Judiciary Committee. My name is Mike Davis. I'm a retired Wyoming Supreme Court Justice. I served on the Wyoming Supreme Court from 2012 to 2022 when I reached the mandatory retirement age of 70. I also served as Chief Justice from July 1 of 2018 to June 30 of 2021. And as such, I was the chair of the Judicial Nominating Commission for a period of 3 years, and I believe about 15 nomination processes. Before that, I was a civil trial lawyer. Before that, I was a district judge in Cheyenne for 4.5 years. And that should tell you I went through the process twice, once to become a district judge and once to become a Supreme Court justice. And before that, I was a civil trial lawyer with Yonke and Toner in Sheridan, Wyoming, for about 26 years. So I have some experience with Wyoming's merit judicial selection and appearing before judges who have been produced through that system and the Supreme Court, about 20 cases that I handled there, going through the process myself, serving as the chair of the nominating commission. I know that the members of this committee want to make decisions that are best for the citizens of Wyoming. And I think we could all agree that an operational and respected court system is something we want to make available to our citizens. I knew two of the people who were in the legislature that sponsored the current legislation. One of them was my law partner, Larry Yonke, and the other was a guy named Alan Simpson, who at the time was in the Wyoming legislature, like you are, and then went on to become our senator. And their goal, which they succeeded in, was to provide a system which was produced an independent judiciary, enforcing the rule of law and freed from political processes. And I think they succeeded. The people of the state of Wyoming voted to adopt the constitutional amendment without any kind of Senate involvement. And I'd like to talk a little bit about how that system works in a minute. I read in an article by former Chief Justice Kite that 30 states now employ a merit selection system like that of Wyoming, and that there are probably some variations. My conclusion after all of those years is that the chosen system has worked well and produced good judges. One thing I'd like to remind you is that you can't appoint or nominate or appoint someone who doesn't have to be a judge. And so the commission deals with the pool it deals with. And a successful private attorney may not want to be a judge or a justice for a lot of reasons, including income, enjoying the kind of subject matter they work on, enjoying the freedom of not being bound by the strictures that limit judges and justices. So the commission has to take the best of the willing. And even sometimes we try to talk a great lawyer into applying, thinking that person would be a good judge or justice. And sometimes the commissioners and the Chief Justice succeed in that, and more often they do not, because we all choose our path. As you know, the lay commissioners on the commission of the nominating commission are appointed by the governor. There are 3 of them, and the 3 lawyers are elected by the Wyoming State Bar. The elected governor has his own interests in appointing good commissioners. Those tend to be community leaders, maybe those with a history of prior government service. And these are people who can hold their own with attorneys and the Chief Justice if their judgment is different than the chief's. Oh, and I should have added, the Chief Justice serves only as the chair and can only break a tie. Doesn't normally have a vote. I've heard some theorize that the attorneys involved in this process somehow overwhelm the lay representatives. And that was never my observation at all. I just don't think it ever existed. And I didn't see it. I can tell you that at times I had to break ties. There were usually, I hope I'm not violating the rules, but my process was to ask each member of the commission after they had gone through their process to list the 3 best in order, 1, 2, 3. That information never goes to the governor, but the ties were always on number 3, at least in the commission's eyes, and those ties were not lawyers against lay people. They were a mixture. Checks on the system have been mentioned. The governor is elected, and he has a vested interest in selecting able commissioners, and that happens. The bar takes the selection of judges very seriously, and therefore their representatives on the commission equally seriously. Lawyers want good judges and justices, and they try to elect commissioners who will assure that. Another check is that in the period, the first general election more than a year after a judge or justice is selected, he's subject to a retention, he or she is subject to a retention election where the people get to vote on whether to retain that jurist. The question would simply be, should Michael K. Davis be retained in office? And then in addition to that, and after that, there are periodic retention elections. For the Supreme Court, that's an 8-year period. And there has been a Supreme Court justice who was not retained during my lifetime. And then, of course, there is the Commission on Judicial Conduct and Ethics, which is sort of the police force of the judicial branch. If a judge or justice has been shown to have violated ethical rules, the commission can recommend sanctions to the Supreme Court up to removal from office. I wanted to point out to you, Mr. Chairman, that the expressions of interests are about 25 pages long, and they ask for a great deal of sensitive and highly personal information that an applicant may not want disclosed publicly. And you can imagine that if there are 20 applicants for a Supreme Court position, that would add up to about 500 pages of reading, kind of a good long novel. And of course, there would be candid appraisals, which are sought from an applicant has to pick out three judges and three lawyers, and then have personal references. And this applies across the board, including to the Wyoming Supreme Court. Then the process is to winnow down to a level that can be interviewed, and that requires a vote. And when in doubt, this resolution, in my experience, has been to go ahead and interview more people rather than less, but it's usually between 8 and 10. Sometimes the applicants are such, you have so few applicants, maybe you have less than 10, and those who could qualify and be good judges maybe as few as 5 that get interviewed. So then there are interviews, and I would observe that the lay and lawyer members of the commission do a fantastic job of interviewing the applicants. You want to find out if this person, in addition to having the technical skills in the background, has a judicial temperament. Is he going to treat people well, or is she going to treat people well, yet be firm enough to manage a docket? All of this has to be completed within 90 days, including the governor's selection. After the commission finishes its work and sends up 3 names in alphabetical order, he has his own team vetting and people and he looks at their packets and interviews all the applicants personally. The commission aims to make his job just as hard as it possibly can by sending up 3 extremely well-qualified applicants. Anyway, that's done within 90 days, and a new judge takes the bench. Senate confirmation would make this kind of a timeline impossible in many, if not most cases. In the case of the Supreme Court, let's just take a hypothetical. Imagine that if you have a judge who resigns, ages out, retires after your session. And so it could be, what, up to 10 months. But let's just take a hypothetical of 6 months. Let's just say that there are 10 Supreme Court cases per month. That's 60 cases. The Supreme Court's practice, and in my opinion, it's a good one, is to appoint a district judge, which it's authorized to do by the Constitution and the statutes of the state of Wyoming, to sit on the Supreme Court. I don't know how you could possibly get that many cases covered for that kind of period of time with district court judges. They have jobs. They are holding jury trials. They have speedy trial limitations. They have all of that. I've had the experience of having difficulty getting one Supreme Court justice to, covered for when there's a conflict because of the busy dockets of the judges. And I've called and got a, sorry, Chief, I just can't do that. I'm tied up with other things when your argument schedule comes up. I would also mention that the skills of an appellate judge and the skills of a district judge, trial judge, are different. I've been both, and I went through the learning curve to, I hope, become a good one. And there's a learning curve to learning to do that. Litigants and lawyers, if that delay is in there, would result in an ever-changing series of an ever new composition of the court, if you could even pull it off. And that can be a problem. That is a serious problem. You could say, well, why don't you just stick with 4 then? I mean, at one time, Wyoming had a 4-member Supreme Court in the 60s. Well, guess what? You will find a whole batch of per curiam opinions, means for the court, and they say, sorry, folks, we're tied, district court's affirmed. And that's the result that happens. Of course, there's some expense aligned with getting district judges from various parts of the state to the court. And lastly, I'd say it's a real good idea to have people on that court, because Wyoming Supreme Court is the court of first and last appellate resort. It's your only shot for an appeal. And you ought to have 5 people on there, and there ought to be a decision. And trying to work in Senate confirmation that's going to delay all those dockets would have a terrible impact, I think. I also would suggest there's not a lot that you could learn through a Senate confirmation process. Judges can't answer questions about how they would rule in the future, potential judges. And an applicant for a judgeship is bound by the rules that a judge is bound by. You've seen that kind of impasse play out in the United States Supreme Court. It's not a very pretty thing. I'm getting to the end, Mr. Chairman, and I'm sure you want to get me pushed along to finish up. I sort of got pushed to the front here myself this morning, but I did have some notes, so hopefully this is organized for you. Finally, I think Senate confirmation would have a negative impact on the public's perception of both the Senate and the court system. Currently, citizens trust the courts more than the other branches of government. Injecting the power in the Senate to reject an appointee who has already undergone extensive vetting by both the commission and the governor for unspecified and perhaps political reasons cannot improve what is already the best system possible. So there's that negative impact. To just summarize, I obviously oppose the Senate confirmation process. Wyoming has the best method for selecting judges that has ever been developed. It would be a step backward and inconsistent with our 50 years of experience with that system. So I would urge you to reject the constitutional amendment and just leave the Constitution as it is. Thank you, Mr. Chairman. I'm happy to answer any questions.
Thank you, Mr. Former Chief Justice. Questions? Okay, Representative Lean?
Thank you, Mr. Chairman. Thank you for coming today. My question has to do with where a layperson may be able to research judges prior to their voting record. I know that the courts say that they're open, but it's an adverse process to be able to get into the courts. It's not time conducive. Paying for copies is labor, or it can be monetarily against somebody's ability to research what a judge has had for an outcome. So could you direct me to some resources where an individual may be able to research how a judge has voted in the past?
Mr. Chairman.
Mr. Former Chief.
Representative Lena, that's a very good question. This would be the time when there's a retention election that you're talking about. Or I suppose you could be interested in, if a district judge like I was wants to be on the Supreme Court, what's this fellow been doing? One of the resources that's available is a poll that the bar does of all.
Could I get you to speak into the microphone? It's a little
Sorry, I
faint
turned
for
to,
that.
haven't done this for a while. So one of the resources is a poll by the bar. The bar asks the members various questions about sitting judges, if it happens to be a sitting judge. And the membership of the bar replies to those, and if the judge or justice is up for retention, they are asked, should we keep this judge or not, in that poll? And that's available to the public. It's on the Wyoming State Bar's website. Another resource that I hope will come online is we have now got electronic case records. And in some jurisdictions, those are completely open to the public. And my position was that you should be able to access any case electronically as a citizen that you could access if you went to that courthouse like you were speaking of and went through this involved process. And you probably can run a person search through the system, and you could kick up Michael Davis and you'd get a list of cases that I decided if that system were done that way. Lastly, I think maybe in the community, the commission, well, I should probably add a little more to that. The application is extremely detailed, and the feedback that comes from judges and attorneys who are evaluating that applicant's ability to serve as judges. And those evaluations can be pretty brutal and negative. Provides the commission itself with a lot of information. It doesn't help the public any. So in terms of that process, the amount of information that's been made available to the commission is very substantial, and the governor goes a step further and waits, the names of the nominees become public, and he waits his entire 30 days and waits till he's got a big old pile of letters from the public and other lawyers and who knows, judges saying, yeah, this particular person is a good applicant or not. And so I think there's in the future going to be some process. Oh, and I would add one other thing about the process. In districts where there is no commissioner from that district, the governor appoints an advisor to talk about the situation. It's a lot different to be a judge in Cheyenne than it is to be a judge in, say, Sundance. So I hope that answered your question.
Further questions? Representative Webb. Representative Webb.
Thank you, Mr. Chairman. And my question is along those same lines, and that's outside of the state bar and the executive branch, where does the common person where is the common person able to have his influence on who should be a judge or who should maybe not be a judge?
Former Chief Justice.
Well, of course, there's an influence through the governor who will not want to appoint someone in that way. There's also the retention elections. And you don't have a retention election before the person is appointed, but there have been judges removed. In fact, it was kind of a blood sport in my former county of Sheridan, because I think we had 3 of them removed there, and there's enough, that's an opportunity. And very often, well, I would comment on the 3 Sheridan County judges who were removed. There was organized opposition to them, and it went public. One of them who was removed, a leader of the opposition, owned the radio station and radio stations in Buffalo and Sheridan, and that's how they got the information. So I think it's out there, and I think my hope that, I guess another thing I haven't even mentioned is, how are they doing at the Supreme Court if you're talking about judges? Of course, the Supreme Court is the last step as to state legislation, but there is the potential for review by the United States Supreme Court, and how that turns out may reflect on the court. So I think if a person wants to gain some information, it's available, and it's through the bar poll and various other sources. If you wanted to talk about elected judges, there are about 10 times the disciplinary complaints against elected judges than there are against judges who go through a merit selection process. The talents that make a good politician, and I'm obviously not a very good one, aren't necessarily the talents that make for a good impartial judge.
Representative Brady, just a reminder to the committee, we probably have a dozen or more additional witnesses on this bill draft, so Representative
All right.
Brady.
Thank you, Chairman. Thank you, Justice Davis. I haven't quite got that in my head yet, all the discussion. Do you believe the people of Wyoming have any interest in knowing who has applied to be a judge? And I do have a follow-up, if I may.
Former Chief Justice.
First of all, I guess they could know, because I looked back at the rules of the Judicial Nominating Commission, and one of the things that they could disclose is the list of what the expressions of interest, the people who have filled out that form. They could make that public. They have not, and in my opinion, it's because lawyers don't want it. If I had been practicing law up in Sheridan, I had some pretty good clients, and all of a sudden I'm putting myself in a position where I couldn't finish a case that's going to take 3 or 4 years, maybe those clients would not come to me. But it's something that could be done. The process varies from state to state. For example, in Nebraska, it's my understanding the interviews by their Judicial Nominating Commission are public. And so I suppose it could be done, but I'm pretty sure lawyers don't necessarily want to, because the expression of interest really dives deep and gets into everything. There's a question on there, is there anything you think we should know? And I made a disclosure of something in my own application, because I thought they should know it, and it was not a terribly proud moment that happened to me in my personal life. I don't know. That's a policy decision, and that could be changed, I suppose.
Thank you.
Follow-up, if I may. Thank you, Chairman. And another question here is, if it's been said that the governor does not have political interest in appointing members, you say it's not political at all, or it's been said, but also the governor does have an interest. So how do we separate those, where there's an interest yet it's not considered political when?
Well, I can't really tell you what's in the governor's mind. He's got 3 names, that's all he's got. He can't say, he could say, I don't want to appoint any of them, then the Chief Justice gets to do it. I don't know what influence there is on the governor that's political. I know that the system is designed so that the choices are so limited. Everybody involved is, as a judge, is qualified and could serve as a judge. You have to remember, judges and justices don't go out looking for issues to address. A case comes to them and a decision is made, and they follow the law. And so I guess I just see that aspect of the system being adequately taken care of. And my sense about governors is that they've made pretty darn good appointments, but they don't really have any choice but to appoint somebody who is going to be well qualified and good in the job, because that's all they're going to get when the commission sends 3 names.
Further questions? All right.
Thank you.
Who's going next? Thank you very much for being here, sir. Please.
My name is Michael Golden. I'm a retired Chief Justice, and before I was chief, I was a justice. I was appointed by Governor Sullivan in 1988. Before that time, I graduated from the University of Wyoming College of Law. Then I passed the bar exam. Then Uncle Sam needed my services desperately for 4 years, and I served as an Army lawyer, a Judge Advocate General. I served in Korea for 13 months. I also, before that, attended Armor Basic Training in Fort Knox. After Korea, I rotated back to the United States and served in the Judge Advocate General's office in Washington, D.C., in the Pentagon. I interfaced quite regularly with United States attorneys in the various states, got to participate in several trials in that capacity. And following my 4-year term of service, I joined a law school classmate, John McPherson, in Rawlins, Wyoming. His senior partner, Bud Brimmer, had just been appointed by Stan Hathaway to be Attorney General for the state of Wyoming. I had a very active practice in Rawlins. We represented a number of clients, corporate and individuals. My practice involved divorces, criminal defendants. At the time, there was not a public defender in Rawlins, and my partner, John McPherson, had discussed this situation with the county commissioners, and they agreed that they would sign our firm on to represent indigent defendants in criminal cases. And so part of my active service was representing people who had been accused of serious crimes. I could go into some detail about some of the interesting clients I had from the penitentiary and elsewhere, but you don't need to know that. I also represented both school districts in Carbon County. And it was in that capacity that I gained a good deal of knowledge about the school finance situation. If you'll recall, in those years, the system was undergoing a good deal of stress and concern because of the financing involved in trying to make quality education affordable to all students in Wyoming. The legislature acted on those concerns and established the system for financing public education. Following my practice in Rawlins, I had the opportunity to move to Casper. I had lived in Casper from the age of 10 until I went into the law school and then on to my Army service. I found memories of Casper. At a point of personal pride, I can look over your shoulders and your heads and see the football field that I played on with Coach Harry Gildane. I have many fond memories of that. In Casper, I had a varied practice of personal injury litigation, medical malpractice litigation. I also was able to serve in other capacities, but my focus in practice was civil litigation. At the time that I expressed interest in a vacancy on the Supreme Court, that was in 1988. I had served 3 years with Governor Sullivan on a number of committees that concerned attorneys and any of the problems that they may have had. And following my appointment to the court, I had the pleasure of serving with any number of the judges before they retired, or as Justice Davis mentioned, there was especially one celebrated case on the Supreme Court. One of my fellow justices, because of a number of his decisions, but principally a very serious criminal proceeding, the voters decided they would not retain him. And they had that opportunity, and they took it. The other trial judge that Justice Davis was talking about had a similar problem. He was a district judge, and he had proper word here, he had upset a number of the voters in his community, a number of the lawyers in his community for his court proceedings and how he conducted them. In particular, he would conclude one legal matter at an evening session, and then he would immediately take up the next matter before him, and the case would run into the late hours past midnight. The voters decided that they didn't think that was the proper way to run his court, and they had the opportunity to seek his removal, and he was removed. When I was a Chief Justice in 1994 to 1996, I did not have the occasion to sit with the nominating commission to consider any vacancies on my court. But I have certainly followed it ever since and have a keen interest in it. Most importantly, recently, one of my former law clerks, Bridget Hill, was appointed by Governor Gordon. And I was so very pleased that Ms. Hill was appointed. A top lawyer, a very nice person, very personable, very intelligent. So my witness is that the nominating commission and the appointment by the governor works very, very well. In my experience as Chief Justice, I had the occasion to talk to all of the Chief Justices across the United States. We hosted the Chief Justices Convention in Jackson, Wyoming during my term as chief. And in my conversations with them, they assured me that they thought Wyoming's system was the best that they had ever seen. And so my personal witness is, I agree. I don't see any need to have a Senate confirmation for this position. We've seen some interesting episodes at the national level. Although I have some personal comments about that, that court has weathered the storm, and the court is fine, and it proceeds as it's supposed to, paying attention to the case before it, doing a great deal of legal research with their law clerks, discussion among the justices in their private conferences, and the system is the same here in Wyoming. Each justice on the court has a staff of law attorneys who are very well educated, who are dedicated to their job and they fully staff the justices on the court. In my view, it is not a broken system. The citizens of Wyoming have an input. Yes, the lawyers have an input because they are the ones who will see the people who are interested in ascending to the bench. In my experience, it is the greatest system in the country for selecting judges. And with that, I would close with inviting you to consider the other material that you will have before you. One in particular is a former law professor at Wyoming, Bob Kiter, and I believe he has submitted some information to you also. I think I can say without contradiction, he also agrees that this is the best system that the state could have going forward. So thank you very much.
Thank you, former Chief Justice. Questions? Seeing none, appreciate your testimony this morning. For further witnesses this morning, out of respect for the prestige of the first two witnesses, we've gone a little long. I ask that the rest of the witnesses on this topic be a little more concise. We really are up against some time issues here, so who's next?
Thank you, Mr. Chairman, members of the committee. My name is Emily Madden. I am from Goshen County originally, but I practice law here in Casper, and I'm here today on behalf of the Wyoming Trial Lawyers Association. We are the state's largest voluntary organization. Our members are family law practitioners, criminal defense, civil plaintiffs, and general practitioners, and we would ask that you oppose this draft resolution. Whenever I read a proposed change to our laws, I ask the same question, and that is, what problem are we trying to solve with this? And after reading this draft and asking that question, I am unable to identify the problem. And like everyone else has said here, Wyoming's merit selection process is truly the best. And my perspective on that is that my practice takes me to federal and state courts across the country. And everyone that I practiced against in those jurisdictions who have practiced here as well tell me about that. And my perspective is also not just from appearing in courts in Wyoming on behalf of my clients, but also the time that I have spent in chambers working alongside judges, both as a judicial extern and a postgraduate law clerk. I worked in the 2nd Judicial District in Albany County, the Federal District Court in Cheyenne, the 10th Circuit Court of Appeals, and the Wyoming Supreme Court. And across all of those levels and with all of those judges, the work was always deliberate, principled, and fair. Now, as a practicing attorney, that does not mean that I have always agreed with the results, but at least I have always known that it was fair. I have never questioned whether the decision was based off of anything other than the law and the facts before the court. And I have never questioned whether it was based on something like partisanship, politics, or public opinion. And that is the reality in jurisdictions that have politics and partisanship involved in the judicial selection process, specifically Senate confirmation in exactly the form that this draft resolution wants to add to ours. For example, one time I was in a case in a jurisdiction with Senate confirmation, and during the mediation, the opposing counsel suggested that the judge's political affiliation would favor their side and hurt ours. And I will never forget the look on my client's face when that was communicated to us. And to me, it was jarring as a young Wyoming attorney, apparently naive to the realities of other areas where the law is practiced, because that is not how it is here, but it was in that jurisdiction. And to my client, before that was communicated, she had viewed the courthouse as a place where she could go and the merits of her case would be decided before anything else and without consideration of political affiliation or who appointed that particular judge. That is the reality that this proposed resolution seeks to inject into Wyoming's practice. And I think that is a risk that should not be taken. So I return then to that threshold question of asking if Wyoming's judiciary's decision-making process is not the problem that we are seeking to solve here, what is it then? And from what I have seen in recent discourse, the recent criticism that's been aimed at Wyoming's courts, it seems to spring from some of the more recent high-profile decisions that have been decided. And I can certainly understand that those decisions have garnered strong reactions. But that is just a sliver of the work that the judiciary is doing on a daily basis. In fiscal year 2025 alone, there are 119,000 cases that have been filed in Wyoming's circuit and district courts. And those are just the ones that have been filed this year. Those don't even count the ones that were filed in years prior, but that remain active in litigation and open before the court today. And across those cases, those judges will make several decisions along the way. In one of my cases last year, there were more than 30 pretrial motions filed on evidentiary issues alone. And not one of those decisions made headlines, but it did impact the case and my client's reality on a very personal level. The cases that are decided are just like that. They decide issues like whether a roughneck in Sweetwater County is going to get workers' compensation benefits, whether a rancher in Sheridan County can uphold their water rights against an upstream neighbor, and whether a University of Wyoming graduate student will get custody of their child. This is the judiciary that most Wyomingites encounter, and this is the judiciary that your constituents rely on. Senate confirmation may sound like an added safeguard to this process, but it does inject politics and partisanship into a process that is deliberately designed to keep it out. Once political considerations creep into the judicial selection process, the public will inevitably question whether the judicial decisions also turn on those same considerations, just as my client did that one day in mediation. If any Wyomingite asks you to support this draft resolution, I suspect that it is because of those perceived issues with those high-profile cases. But I can assure you that when it is their case that's being decided, they will want no trace of politics in that process. Supporting this resolution because of a disagreement with those cases is like putting your thumb on the scales of justice today, only to forget that one day you will need them to balance for you or your constituents. I don't think that is a risk that we should take here today or in the future, because the reality is that Wyomingites already have the tools available to them to ensure that there is fairness and accountability in Wyoming's judiciary. There is jury trials that will ensure that local values are embedded into the results of cases. There's the retention election that we talked about. There is, referring to questions that were asked earlier, the Wyoming State Bar does publish all of the polls of lawyers for the judges who currently sit in Wyoming. There are legal research avenues at local law libraries for people to go and research decisions of Wyoming judges, and that is for free. I do know that the Natrona County Bar does pay for a substantial amount of Westlaw access, and anybody, regardless of whether they are a Natrona County citizen, can go into the Natrona County Law Library and get access to that material. I also want to add that part of that process is if you are a litigant and you disagree with a decision, you do have the right to appeal. And if after an appeal you still feel like the result is unjust, the result and the answer is to return to you, the legislature, to change the law, just as we did a couple months ago with Wyoming's Post-Conviction DNA Testing Act. Respectfully, the answer is not to change the process by which we appoint judges in this state. If in those circumstances you or your constituents still feel like judicial decisions and the results of them are unjust, I would urge anybody in that situation to ask themselves whether the issue that they have is really with the law itself or the judges who dutifully and faithfully applied and interpreted the law. In closing, this resolution would not make our courts stronger or judges more accountable. And quite frankly, I think it would be a disservice to your constituents because they deserve to walk into a courtroom knowing and trusting that their case will be decided fairly and impartially and not politically. Thank you.
Thank you, Ms. Madden, for being here. Questions? Representative Lean?
Thank you, Mr. Chairman, and thank you, Ms. Madden, for joining us. I also want to thank you for your work on the DNA legislation last year. That was fantastic. I want to go back to what you said about no trace of politics in the process. In the nominating commission, could you explain to me where the transparency is for the public to know who the applicants are? And I know a former justice touched on it earlier, but if the public is not able to know who applied for the judge, how does that allow the public to have a voice in the process?
Ms. Madden?
Thank you, Mr. Chairman, and thank you, Representative Lean. I may not be the best one to answer that question. I know that Elena has, I think, previously served on the Judicial Nominating Commission, and she's up next. So she would probably be the one to tell you more about the rules and the inner workings of the Judicial Nominating Commission. So I'll defer to her if that's okay with everyone.
Other witnesses will have their chance to take questions, but this one's to you. So if you wish not to answer, that's fine.
Sure. So the Judicial Nominating Commission, as I understand it, as Justice Davis said, is currently not available to the public. And I think that there are ways that he's mentioned that it could be done so that the list of applicants are available and publicly available to constituents. And I think that that is something that, well, I can't speak on behalf of the Wyoming Trial Lawyers Association on that, but personally, I believe that that is something that is and could be an improvement to the system if it is something that transparency in that realm is what this committee would feel is necessary and an improvement of that. But I don't think that it extends to injecting Senate confirmation of Wyoming Supreme Court justices or judges at any level in this state. I think that there are other ways that we can look at transparency and accountability within the judicial nominating process that does not get to the level that this proposed draft resolution does.
Thank you. Further questions? Representative Kelly.
Thank you, Mr. Co-Chair. First, I concur with the concern about injecting partisanship and politics into the selection process, in ensuring the most politically adept to become judges, not the most qualified. We've seen what happens in other states, and we don't want our court proceedings to become national events. Nonetheless, as far as Senate confirmation goes, currently there are many appointees that require Senate confirmation in Wyoming. The Wyoming Business Council, the Charter School Authorization, Board of Pharmacy, the State Board of Parole, the Board of Barber Examiners. Do we have evidence that any of these have become hopelessly political? I mean, are there people afraid because of their politics they might not get paroled? I mean, what evidence do we have that a simple Senate confirmation of a Supreme Court appointee who's already gone through the process we have right now, just that final step of the public being allowed to have some input on it? Do we have evidence in other places of positions that are appointed that require Senate confirmation that they've been infected terminally with politics?
Ms. Madden.
Thank you, Mr. Chairman and Representative Kelly. We do have evidence that even something like Senate confirmation does impact not just the way that justice is delivered, but that the way that justice is perceived. And the one example that I gave today is my client in mediation. I mean, I truly will never forget the look on her face when she realized that politics and partisanship would have any role in the resolution of her case, or even the fact that it was being used as a bargaining chip was something that was really troubling for her and for myself as well. There are studies and I'm sure statistics that we could bring to this committee at a later date or supplement if that is something that you'd like on that, whether the statistics are there for other appointees like the barbers or the parole board. I don't know the answer to that. I haven't looked into it. But I do think that the judiciary and specifically the Wyoming Supreme Court is so differently situated in its role in ensuring that justice is fairly and impartially delivered in this state, that the concerns for injecting politics and partisanship in that realm is far more concerning and risky, I think, than those other appointee positions that you mentioned.
Thank you. We're going to go online. We've got a whole list of people online. We'll bring a few of those witnesses in, being fair to the people in the room and the people online. I think that's Carrie Egan.
So, Mr. Chairman, for the folks online today, we have Tom Harrington, Jason Oakes, Stuart Day, and Mary Elizabeth Galvin.
Bring in the first one. I'm reminded that brief to a lawyer is different than brief to other folks. But we really do need to keep the testimony tight.
Mr. Co-Chairman, you just have to remind them that they're not getting paid by the minute, and every minute they're here, they're losing money.
Losing
that they
money
could
to
be
their client,
practicing,
paying
so
client pay.
that might speed things up.
Somebody coming up, Carissa?
Mr. Chairman, they're declining to be promoted. So we have Mary Elizabeth Galvin, who will be joining us.
Ms. Galvin?
Yes, thank you very much. It's Mary Elizabeth Galvan. I'm an attorney in Laramie, Wyoming. I have been practicing.
Ms. Galvin, you're very faint. Can you get closer to your microphone or turn up volume or something?
I will see what I can do. Is that better?
That's a little better. Thank you.
I have been practicing law in the state of Wyoming since 1980 for 45 years. I will be brief. I thank you for reminding me, sirs, that I'm not being paid for my time. But I think I echo the comments of everyone who has preceded me. And I would like to remind this committee that the judiciary is here to interpret the law to ensure that it is executed correctly, as well as they can. The basis of that lies in the integrity of the judicial system. Our current means of selecting judges for all three of the courts in this state provides exactly that integrity. The nominees are vetted by a panel of attorneys who have devoted themselves to that process, and the selection process is going to goes to the governor for the three names that the governor is presented with. So I would very strongly urge this committee to consider both the motives for changing the system and the ultimate effect on the system if it makes this mistake. And I'm very serious. I believe it is a mistake. I come from Texas, where judges are elected. I have 4 siblings practicing law in Texas, where judges are elected. And I've often teased them about having to go before a judge, wondering whether or not they made more contributions to his campaign, to the judge's campaign, than their opposing counsel. I believe that removing the selection process from attorneys who are familiar with the work of the attorneys and the reputation of the attorneys, and from the governor who is in the position to vet those names, would compromise the integrity of the judicial system. Thank you.
Appreciate you being with us this morning, Mr. Galvin, and appreciate you being brief with your comments. Thank you so much. Any questions? And none there. Do we have Jason Oakes, maybe?
We do, Mr. Chairman.
Good morning,
Morning,
Mr.
Mr. Oakes. We are up against the clock, so please be brief and let us know what we need to hear.
I'll be really quick, and thank you very much, Mr. Chairman. I've been a trial lawyer for 20 years. I've represented folks throughout the state of Wyoming, everywhere from moms and dads and child custody cases to the city of Cheyenne and city of Casper in the nationwide opioid litigation. So, and everything in between. And I can tell you that there isn't a whole lot of remaining sacrosanct spots in this state where we can do our work and be people and citizens of Wyoming and not have the political filter or political injection that we find just about everywhere else. We're seeing it in our schools, unfortunately. I've even seen it in church, unfortunately, and it sure as heck is present at the Thanksgiving dinner table. But one place we can be free of it is our courtrooms. Our courtrooms allow us to have the merits before the case, before the judge, to make the decision without deciding who's aligned with me politically and who isn't. It embodies Lady Justice. Lady Justice, who we all know, who holds the sword and the scales, but has the blindfold over her eyes. I have a tremendous concern that if we inject political bureaucracy into the judicial selection system, we might as well just rip the blindfold from Lady Justice, because what it says is we, not the people, we the government, get to decide what the laws are and who gets to interpret those laws. And I would submit that that is in direct contradiction to the ethos that Wyoming breathes in and out every night, which is the belief in personal liberty and limited government. And we are successful with limited government by doing things that keep the government out of our daily lives. Thank you very much.
Thank you, Mr. Oakes. Appreciate the brevity and the comments. Any questions? Thank you very much. All right, back to the room. Ms. Stadelli?
Thank you, Mr. Chairman. Members of this committee, my name is Elena Stadelli. I am the president of the Defense Lawyers Association of Wyoming that represents the Civil Defense Bar. So not criminal when you hear defense. We represent everybody from your mom and pop business to a Fortune 100 company, a family farm, to municipalities when we're hired by the Wyoming Association of Risk Management to defend civil rights litigation. We run the gamut. So I will speak in two capacities. One is as the president of D-Law, as we call it. And we're typically on the other side of the V from the WTLA. We don't agree on much, but we agree on this. And that is that the people of the state of Wyoming in 1972 recognized that a system where politics had any say in the appointment of judges, or the election of judges as it was then, was not appropriate. It undermined people's faith in the judiciary. You had many more issues concerning judicial misconduct, and people had the perception, as Ms. Madden discussed, that, well, this judge is going to rule a certain way because I made a campaign contribution or because we were buddies in high school. I can tell you, as someone who has practiced in this state for 18 years and who was a staff attorney for 2 years to the Honorable Thomas Sullins, who has since retired, that that is not what happens in Wyoming courtrooms. And I think we should trust the people of the state of the state of Wyoming before we do something drastic like amend our Constitution. We've seen what injecting politics into the judiciary can do. And Senate confirmation, make no mistake, will do that. All you have to do is look at what the federal system does. Think of the circus that was Justice Brett Kavanaugh's hearing. And I'm not going to get into any of the side of that, whatever your politics are. But to say that that undermined people's perception of the Supreme Court, their perception of the Senate, their perception of what qualifies someone to be a justice, I think was extremely damaging to the rule of law in this country, and I would hate to see it happen in Wyoming. To me, this is a solution in search of a problem. We don't have a problem with judicial selection as it currently stands in the state of Wyoming. The people do have a voice. You have to remember that as members of the bar, we're citizens of this state too. We're voters. The decisions of the Supreme Court affect us as well, not just our clients. We may disagree with them. We may agree with them. I may disagree with a ruling on a personal level, but agree with it for the group of clientele that I represent. But if we start getting into, as Mr. Schriftman suggested, well, how are you going to vote on a certain issue? One, that violates the Code of Judicial Conduct that all of our judges and applicants abide by. But two, it just undermines the impartiality of the justice system. Further, I'll state that Senate confirmation, or the questions that a Senate may or may not ask in confirming a particular judicial candidate, may not be as revealing as you think. And I would point to retired Justice Anthony Kennedy as an example of this. People thought when Justice Anthony Kennedy was appointed to the US Supreme Court, he was going to be a reliable conservative vote. He's one of the great centrists that the court has ever seen, and in the latter part of his career voted with the quote unquote liberal wing of the court far more often. So again, I would ask what problem we're trying to solve here. As for the people having a voice, we do have a voice. We can vote to retain. We can talk to other members in our community. And if you want to talk about a judge's voting record or ruling record, all you have to do is get on the comment section of Facebook. I've been there. It's not pretty. It's often inaccurate, but we also have the resources for people to find out that information more often. I will just say that I trust the people of the state of Wyoming from 50 years ago who amended our Constitution to adopt our current system. It hasn't failed us. Have there been decisions that have been overturned? Sure, but that's what happens in any court. And I would ask you to look at who is currently serving on our court. These are not ostentatious individuals who go out and who are glad-handing, raising funds, kissing babies, doing anything like that. They are quiet, diligent students of the law. And that is who you want deciding your case. You don't want people who will get up before a Senate committee and say, oh, sure, I voted on this, or let's discuss in detail a mistake I made in high school that has absolutely no bearing on how I'm going to decide a case when it comes before me. You will further undermine public trust in our judiciary. And I work with dozens of out-of-state lawyers on all types of cases. To a person, we are complimented on our judicial selection process and our judiciary. And this is from people in states where they have a similar process, but have Senate confirmation. This is from people in states where judges are elected. And they say, we know that when we come into Wyoming, we are going to get high-quality rulings that are based on the facts and the law dutifully applied to those rulings. When you add in Senate confirmation, and this is not to single anyone here out, but you see it in other states, you see it on the political level. Rather than being a process to actually vet a candidate's qualifications for the job, it turns into a campaign opportunity. Well, I'm going to give you a campaign speech in the form of a question. That has nothing to do with whether or not someone is going to faithfully apply the law to the facts of a case, whether they're an ethical person, or whether they have a judicial temperament. It becomes a political grandstanding opportunity for elected officials rather than an actual judgment of whether any particular candidate is suited to that role. And I don't think anybody can argue with that. I think there's plenty of people who ask questions in good faith, but there are plenty who don't. And it would sadden me greatly to see the institution of the Senate of Wyoming be reduced to that. And it would sadden me greatly to see our judiciary reduced to that. I will address briefly the question about issues of expression of interest. That we do not require any other employee of the state of Wyoming, which judges are an employee of the state of Wyoming, to release their name or any other information about themselves when they apply for a different job. Because, and also as members of the public, right, I don't have a say in whether or not the head of the Department of Family Services, I'm just picking this out of the air, gets to keep their job. Okay, no offense, I think you're doing a great job. Right, but so judges are state employees. They are public servants. They are held to a high standard of conduct, and I have done investigations of judges against whom complaints have been made. It's taken very seriously. I've also gone through the judicial nominating process twice, one of which my name was not sent to the governor. In part, it was disclosed to me by Chief Justice Davis at the time because the community members, the community advisor said, we want someone from this community in this position. We think she's qualified, but we'd rather have someone from this community. The other, my name was sent on, and I wasn't picked by Governor Gordon. And, you know, I don't know why, and that's okay. But I can tell you that it is, I think, fundamentally unfair to ask people who may be looking for a different position to disclose to everyone they work with, the public, and their clients, hey, I might not be here in 6 months. And by the way, here's all of my very personal information out here. Yes, judges occupy a position of trust in society, so do police officers. We don't ask police officers or the Wyoming Highway Patrol to disclose their intent to file for a new position. I think if you did that, and I understand the desire for transparency, I think if you did that, you would see a steep decline in the number of applicants for any position and the quality of applicants for any position. And it's simply out of privacy concerns. Or, you know, maybe this is something I'm just thinking about. I think I'd be good at it. I'm putting my name forward. Well, now I have my partners banging down my door saying, why do you want to leave? I have clients calling saying, are you even going to be able to represent me? The impacts on the practice of law would be real, and we don't ask that of any other state employee. I said I would be brief, and of course, I've gone way over. I apologize for that, but I was trying to answer questions. I will just close by saying the people of this state amended the Constitution 53 years ago to avoid the very problem that this amendment will add back in. That was a good decision. When you have basically representatives of all aspects of the Wyoming State Bar coming out and saying, we think this is a bad idea, not just as attorneys, but as members of the public who are affected by judicial decisions, I think you need to sit up and listen to that. And it's not because we think we're better than anybody else or that we have, you know, some kind of superiority complex, although I'm sure there are many of us who do. But it's because we have a unique window into this that members of the public just don't. We practice with these judges, in front of these judges and justices every day. Our system isn't broken. Please don't become the type of activist legislature that is looking for solutions to problems that don't exist. I would strongly advise that you vote against this.
Thank you for your testimony. Questions? Representative Kelly.
Thank you, Mr. Chairman. I'm also somebody who was passed over by the governor for an appointment, so I understand. We're not talking about electing justices today. We're not even deciding today if nominees would need to be confirmed. It's mentioned multiple times to trust the people of Wyoming. This is for a constitutional amendment where both chambers would have to pass by 2/3 majority with great input for the public, and then have to pass a majority of individual voters and 3/4 of the counties. Is not moving this bill today a statement that we trust the people of Wyoming today?
Mr. Chairman,
Yes.
my answer to that is yes and no, right? I would ask, my question in return would be, where is this coming from? I don't believe that there has been any great clamor by the citizenry of this state to say, our judicial branch is broken. Yeah, there have been a couple of high-profile cases that have created a great deal of discussion, which is what you would tend to see. But I would ask you, out of the roughly 600,000 people who live and work in this state, how many are truly saying, oh, these 5 folks who were appointed by the governor, man, we didn't have any say, we don't think they're doing anything right, and in order to fix that, we need senators to say yay or nay. I don't think that exists. Maybe I'm wrong, and maybe you can educate me on that. To me, this smacks of out-of-state influences trying to hijack a system that is literally the envy of jurisdictions around the country. And so, again, if it ain't broke, don't fix it.
Senator Hicks.
To stay out of this discussion, but I do have a question. So it seems to me like this, your presentation is deviated for what the intent of the bill does. And so I, like you, have not heard a lot of concerns associated with the judicial system as a whole. I have heard a lot of concerns with the nominating process as to how we got to only Supreme Court justice. So let's just focus on Supreme Court justices, those 5. So obviously it's no concern whatsoever with your organization that 3 of the last Supreme Court justices were also previously political appointees of governors that then were appointed to the Supreme Court. So the idea that politics is not involved in this process when you have people that were political appointees by a governor, and then a governor puts 3 more political appointees on the Judicial Nominating Commission, and then we up with 3 out of the last 4 Supreme Court justices that were previous political appointees by governors. Now, I've heard a lot of concern from the people of the state of Wyoming about there appears to be, or at least on the very surface, that there's a lot of politics involved in who gets on the Supreme Court these days, when 3 out of the 4 were previous political appointees of governors. And so that doesn't rise as a concern through the judicial nominating process, that there's an undue, heavily weighed influence associated with governors in that process, given our past recent results of 3 out of the last 4. So that's a question, Mr. Chairman.
Mr. Chairman. So briefly, and Ms. O'Connell, hopefully we'll give her some time to speak, because I have only sat on the JNC as an advisor, and that was when Judge Kerry Johnson was appointed to replace Judge Solons when he retired. But Ms. O'Connell has sat as a member. I would say, based on my own experience going through the process, that the JNC gets the candidates who apply. So if people who were serving in political appointed posts apply, and they happen to be in the top 3 of those applicants for whatever reason, and they go to the governor, then under our system, that's what works. If they were not qualified for the position, they would not be one of the top 3. And then as Chief Justice Davis had stated, the Governor Gordon especially, takes all 30 days that he is given under the Constitution, and people write in, members of the public can write in, but it's ultimately up to him. And I will say this, there have been appointees in the past that I've kind of gone like, oh, I don't know about that person, that seems kind of funky. And then you watch what they do on the court and how they comport themselves and the decisions they issue, and you sit back and you say, actually, this system works really, really well. So yeah, I can understand that concern that members of the public have. I don't know that that concern would be alleviated by adding Senate confirmation in, especially when we have seen what Senate confirmation does on the federal level and what Senate confirmation has done in other states, which is to take someone and rather than saying, can they do this job? Are they an ethical person? And do they have a judicial temperament? It turns into basically a circus and becomes all about politics. I will remind you that our judicial branch cannot speak on its own behalf. They're precluded from doing so. And that makes it very difficult for them to answer, I think, questions that are made in good faith, like yours, Senator Hicks, which is, well, these people were political appointees and now all of a sudden they're on the court. They wouldn't have gotten there if the vetting process didn't allow them to get there. And by that, I mean, the governor is not calling members of the JNC saying, well, you better put this person through. That's not how it works. They're judged on their merits and their merits alone.
Okay, we're 45 minutes long, and Director of the Department of Health is patiently waiting over there for the next topic. And I know these are very important topics. I just want to encourage the committee and the witnesses that, you know, as much as we may want to get a thorough discussion, we are under limited amount of time. That's just the nature of the legislative process. And so we need to get tight. So Senator Kolb, you're up.
Well, thank you, Mr. Co-Chair. You know, it's so many things here. First off, I would never insinuate that the people that are on the Supreme Court are incompetent. That's not the point. But so many things you went over, I just feel motivated now to talk about them. So the connection, the nexus between us and the U.S. Supreme Senate is an insulting connection. Insulting. Number one, we're a citizen legislative body. We're not a professional bunch of legislators that get there, frankly, for probably life. To say that we would handle ourselves in the same way as the U.S. Senate, I'm insulted. That's just ridiculous, patently ridiculous in the state of Wyoming that we would do such a thing. First off, I'll just tell you as a senator, I'd never stand for it. Never stand for that level of rhetoric going back and forth. So there's no connection there. That's a non sequitur. Doesn't connect. Doesn't work. Non-relevant. What's relevant is the part we just talked about and you just heard about from the good Senator Hicks, is that there is a political connection, and that's the perceived issue with this, and that's why we're sitting here talking about this, because there's a perceived connection between AGs, Supreme Court justices, and I like the governor. But once again, when you let one person in this particular case make certain choices up front, certain outcomes happen. And to think that it's other than that is naive. It's a naive proposition to tell me that it doesn't happen like that, because it did. So the facts speak to that. Third question I have is why is it a bad thing to have the people of Wyoming vote on a constitutional amendment? They vote on this. Now, first off, I guess we're happy that 53 years ago they voted a certain way, and you know that was the right thing to do, and that was the way that election went. But to say that now they can't vote or they can't have a voice in this it's not part of what our republic's about. The people have a choice in this state to either say yay or nay on this. It's not something that we're deciding. We're giving them a choice. And to be scared of that choice, I find, I don't know, interesting. Because why are we afraid of what the people of Wyoming want us to do as elected officials? Why is that a bad thing to fear that outcome of such a vote? Because that's what I'm hearing. I'm hearing a fear that we don't want to give them a choice. They don't have the right to have this choice because, well, we don't think there's a problem. But the people that elected me and the people that elect other folks believe there's an issue here. And it is, I guess go back to what I said before, it's political. I want to know why it's not political, and why is it better to have one person politically make a decision as opposed to the Wyoming State Senate have a voice in there. And once we have that voice, that's the end of it. We don't get to come back and get a second chance at it, but it's just part of a process that allows the public, allows an open way of having a dialogue. And I don't see what the problem, tell me why that's an issue. I mean, more than what you've already said, why is that a bad thing to do? To have a vote by the people and then have a process in which the elected people in the Senate can then have a conversation with that said appointee, besides just having one person, the governor, make that decision at the end of the day. Thank you.
Mr. Daly.
Right. So with all due respect, Senator Kolb, you felt insulted by me implying that the Wyoming Senate would conduct itself in the same way as the United States Senate. I didn't imply that at all. What I stated was, in other places where you have Senate confirmation of Supreme Court justices, you see a degradation of the process over time. And you can see this, I'm going to use the US Senate because it's a great example of this, of Ruth Bader Ginsburg's appointment. 99-1 was her vote. And I believe it was the senator from Utah who said, I don't agree with the thing, she stands for, but she's qualified to do this job, and I'm going to vote for her. Contrast that with the appointment of Justice Kavanaugh, also perfectly qualified to sit on the court. And it was weeks and weeks and weeks of ridiculousness. And that was over the span of maybe 30 years that we saw that degradation. Do I think that Wyoming legislators in general comport themselves better than our national representatives? Yes, I do. Do I think that there is a danger that some members of this body will utilize the Senate confirmation process to score political points? Yes, I do. So that is not meant to be insulting to you personally or to the body as a whole. It is based on human behavior and observations made over time. Second, you did not imply, but rather stated that we are afraid of what the people have to say. As I stated before, we are your constituents. The roughly 1,300 members of the Wyoming State Bar who live in the state of Wyoming, who are active, are your constituents. We are the people too. I'm not afraid of what the people have to say. What I am saying, what D-Law is saying, what the WTLA is saying, is that amending the Constitution is an extreme step to solve a problem that doesn't exist. I don't care what kind of system you come up with, whether it's the one we currently have, whether it is Senate confirmation of Supreme Court justices. There will always be an accusation that someone got the job because of their political connections. Our current system, which is, and one of your statements was incorrect, stating that only one person is part of the process to make that appointment. That's not true, is inherently apolitical. Anybody from the bar can apply to become a judge. They go through the process. It is extremely arduous. And then the JNC asks questions, and I can tell you this, I sat through it twice. I wasn't asked anything about my political affiliation, whether I agreed with the governor on anything like that, whether I would vote a certain way. It was, Tell us about yourself. Why do you want to become a judge? What experiences make you qualified to be a judge? What does your practice look like? Those people take it extremely seriously. And to state that it is political, I think, is to ignore the very real and very difficult work that they do every single day. And then, yes, it goes to the governor with 3 names. The public can write in, and he makes the choice. And then if that person turns out to be terrible for whatever reason, the people can vote not to retain them, and we have seen that happen. I would question, though, and this would be my response to Senator Hicks, is can you point with, you allege 3 of the last 4 have been political appointees. What decisions those justices have rendered or authored that would indicate that they are not applying the law faithfully, with fidelity, in a constitutional manner based on the facts that are before them? That's what I would ask. And if you can't point to a case and explain why it's a political decision versus why it is one that is faithful to the law, then I would say your comment is not well taken and is based more on scoring political points than it is on the actual facts of the matter. I am not afraid of what the people of Wyoming have to say. What I am afraid of is an inherently political body trying to fix a problem that does not exist, and that will make the process inherently more political. Now, that is my personal statement. I'm not making that on behalf of anyone else.
Thank you. Follow up, Senator Cole.
Yeah, thank you. So I was accurate. It is one person. It is the governor that makes this choice. He has 3 names in front of him. It is one vote, one person. It's the governor's choice. That was my point about the one person. I want to clarify that. Thank you.
Thank you.
I appreciate the clarification. However, that's not what you said. The record will reflect what you said. But there's not one person involved in this process. It is designed to have the perspectives of multiple people of all experiences and different political backgrounds. And that's the way it works.
Okay, we're at 12:30. Do we have anybody else on Zoom?
Mr. Chairman, we have Tom Harrington on Zoom.
Bring him in.
Hello.
Mr. Harrington, we want to state your name for the record and very briefly, and I emphasize briefly, tell us what you'd like us to hear.
My name's Tom Harrington. I live in Shell, Wyoming. I'm a retired circuit court judge. Practiced law for a number of years as a public defender, prosecutor. I just want to address one issue briefly in that one of the representatives mentioned I can assure you that in this process, the public has a input, specifically when the 3 names are made public after the nominating commission sends them to the governor. The governor gets all manner of communications, letters, cards, emails, phone calls, etc. And when I was privileged enough to be interviewed by Governor Friedenthal, he threw a letter across the desk to me and said, explain that. And it was quite an uncomplimentary letter. So I just wanted to mention that the public does have an input for those 30 days, and the governor takes these things, all the governors take these things very seriously. And I appreciate the comments of the other panelists, and I appreciate the questions of the committee and the chair, and I appreciate the opportunity to be here. So that's all I have. Thank you.
Thank you. Any questions for Mr. Harrington? Thank you. Anybody else on Zoom? That's it? All right. Who's up? Very good. Introduce yourself and briefly tell us what you'd like us to hear.
Understood, Mr. Chairman. Thank you, Mr. Chairman. Mr. Chairman, my name is Devin O'Connell. I'm a practicing attorney from Laramie. I am a Wyoming native from Evanston, daughter of an oil field worker, and I've been practicing law for approximately 25 years. I'm the past president of the Wyoming State Bar. I'm a past president of the Wyoming Trial Lawyers Association. But most importantly, I am a current sitting member of the Judicial Nominating Commission. I can answer a lot of the questions that have been posed and are very important to the understanding of how we pick judges in Wyoming. I am not offended by the concept that citizens want more input into who their judges are. I think that that is critical. I want the public to be very proud, as I am, of the judiciary. Because I will tell you, as I've been a member of the JNC for 4 years, we have vetted 30 judges in that timeframe, 30 in 4 years. The turnover of the bench in that time should be concerning to this committee. It was due to new positions being created by this body in Evanston and a new one in Casper, a new one in Gillette. It was due to retirements. It was due to appointments from a current bench to a higher bench. And I will say that those 30 members are phenomenal. I mean, this system works. I would hope that we would talk about rule changes that might insert more transparency into the process rather than a constitutional change, because I do appreciate that we as citizens want to know who our judges are, and we want a role in picking them. I would be very cautious to say that anything that might chill the application process and the applicant pool, I would be very worried about. We don't have a lot of people applying to be judges, which goes to maybe your question, Senator Hicks, about why have the last 3 out of 4, and I don't know them to be political appointments, so I would have to accept your representation there. The applicant pool is what it is. And we get applications. We sometimes ask people to please apply. And as Justice Davis mentioned, sometimes they do, sometimes they don't. I will also just point that the members of the JNC are 3 citizens that are appointed by the governor, who is a politically elected person. The practicing attorneys who are elected by the practicing lawyers of the bar are citizens and are from your small towns and your communities across the state. The Chief Justice does serve as the chair, but does not vote unless there's a tie. And each member of the JNC can serve 1 term, 1 4-year term. We can never serve again. And that is protected in the Constitution and is appropriate. Moreover, no more than 2 members of the JNC can be from 1 judicial district. So we can't have all of them from Cheyenne and then the rest of the state is neglected. They're from all over the state. And so I want, and we are citizens who are committed to a strong judiciary. I will echo some of the statements where politics does not come up in the JNC. I cannot speak for the governor. That is an inherently political elected position. And in that process and in who he picks as the citizens, there may be some politics that come into there. So I understand that. But in the JNC where we talk about merit, it absolutely does not come into play. And I would hope that we could make potentially some rule changes that would ease this committee's mind about potentially making it more public. I don't see a problem with that, actually. That would be a simple rule change, not a change to the Constitution. And I would urge that this committee would maybe take a look at that. I will tell you that when we interview people, first of all, I'll back up. The expressions of interest are mighty. They are 20 pages long, and you have to have a 15-page writing sample. This is not for the faint of heart. I've also been through the process. You will notice that I did not make it to the final three. So I have been through the process and understand it. And a lot of us do not make it to the final three, but the application is daunting. As an applicant, you have to sign a waiver saying, I'm turning over all of my discipline that I've ever been disciplined for through the bar or for the Judicial Commission on Ethics and Conduct. I have to disclose all that. I disclose, I have to have 3 judges say I'm competent. I have to have 3 lawyers rate me. I have to have 2 references. Now, the 3 judges that weigh in, they are not always a very pretty picture. And so I do want you to know that there is a lot of information that this commission gets, and it is a monstrous amount of paperwork, which it should be. It absolutely should be. We then interview 6 to 7 candidates, depending on the number of applicants that we have in that particular bench, or the number and quality of the applicants. We usually interview 6 to 7. We travel to the court where the vacancy has occurred. So we go to the community where this judge is being appointed, and we speak to the judge who's departing, and we ask, what are the particular needs of this jurisdiction? As was mentioned by Justice Davis, being a district court judge in Laramie County is different than being a circuit court judge in Star Valley. Vastly different communities that we're representing, vastly different judicial needs. And the judge that is going to be picked for that position needs to know those differences. In our interviews, we ask questions that are dealing with a judge's integrity. What is their character? What is their reputation? What are they ethical? Do they have a strong work ethic? We ask about professional competence. What is their knowledge of the law? How long have they been practicing? What is the breadth of their knowledge? We ask about their temperament. Are they courteous? Are they nice? Are they jerks? Do they have compassion? Do they have humility? Are they able to serve without judgment and make decisions that are not cruel or one-sided? Are they devoted to public service? I mean, the willingness to take on this critical role in the judiciary, as you all know, in your particular seats, you're not going to make a lot of money being a senator, being a representative, being a judge. That's not where you are. Are you doing this for the right reason? And we ask all of those questions and hopefully get the answers that will serve. At the close of the interviews, we deliberate, we select 3, and those 3 go to the governor. And at that point in time, those 3 names are released to the public. Again, I will be very open to the concept of making the process more transparent at the applicant level. And I think some judges might not want to be as candid, so maybe that's still kept confidential, but the names, I don't know that we have any problems releasing those names. I will say, Your Honors, that's a habit, representatives and senators, that our current bench is exceedingly qualified. I am very proud as a Wyoming lawyer and as a Wyoming citizen of our current bench. They are exceedingly qualified. We have excellent judges who have chosen that profession not because of wealth, and they haven't been chosen because of politics or because of cronyism, but for their character, for their merit, and their work ethic. And they issue thousands upon thousands of decisions every year. Divorces, child custody, child support, you all know this, partitions of real property, criminal charges, workers' compensation, people who are injured, contract disputes, business disputes, particularly in the Chancery Court, juvenile actions, and so on. And I urge you to protect that system that has led to our very qualified and competent bench. This system selects judges that interpret and who are committed to the rule of law, the laws that you write for them, that they interpret. And I would encourage you not to make any changes to that system that require constitutional changes. Thank you.
Thank you. Questions for the witness? Representative Lean?
Thank you, Mr. Chairman. I have two, and I'll put them together for the sake of time. My first one is, of the 30 judges in the last 4 years that you've had to vet, how many of them are Supreme Court justices? And my second one would be, would you be willing to make a commitment for the rules for the nominating commission to become transparent at the applicant level of the names to be released?
To my recollection, there have been.
Connell, through the chair, please.
Absolutely. Apologies, Mr. Chairman. Representative Lean. To my recollection, there have been 4 Supreme Court justices. Justice Fenn, actually maybe 3, Justice Fenn, Justice Jarash, and Justice Hill. And then the second part of your question, Mr. Chairman and Representative Lean, the second part of your question, am I committed to a rule change? In fact, I have been saying that in speeches that I've been giving across the state, that the JNC is open. I'm only one member, but the JNC is open to consideration about rule changes.
Further question? Senator Crum?
Mr. Chairman, my question for Ms. McConnell is, you talk about rule changes. Do you have any recommendations or thoughts that this committee should consider about rule changes to make things more transparent?
Ms. O'Connell?
Mr. Chairman, Senator Crum, thank you for the question. I believe the rule changes would come through the Wyoming Supreme Court for how the judicial nominating process, at what level they make those transparent. The Constitution drives a significant part of this process. That's one little piece where, at what point in time, applicant names can be released. That is up to the JNC, and I think that we absolutely could consider that.
Senator Hicks?
Mr. Chairman, thank you for your testimony, and particularly with the insights that you bring. When we first looked at this in Torrington, it was all court justices. We narrowed it down specifically to Supreme Court justices. And in my mind, the rationale for that is they're the only judges that rule on constitutional issues. So particularly whether it's constitutional or not. And so the one question that I think that some of us, or maybe many of us, really want to know from a Supreme Court justice is what methodology or philosophy do you bring when you're interpreting constitutional issues? And you see this as one of the largest debate within our judiciary at the national level. You know, what methodologies do you use to interpret constitutional issues? So that was the rationale as to why I've supported this. The question I have for you, being in your position, has that question ever been posed in your time on the committee to any of the prospective Supreme Court justices? Are you a textualist? Are you an originalist? Are you pragmatic? How do you go about on these? Because this gets to the whole issue of some of the more high-profile issues that we're dealing with within the state of Wyoming. And it's very disconcerting, I think, for many of us, is when we don't know the judicial philosophy of an individual that's going to be interpreting our Constitution. And so on your time, was that question ever posed as what kind of judicial interpretation of constitutional issues do you use as your guideline or your playbook or your parameters for evaluating those constitutional issues that come before the Wyoming Supreme Court?
Mr. Chairman, Senator Hicks, in my time on the JNC, I do not recall a question regarding how a specific person's methodology of how they will interpret. It's asked in many other ways. What is your judicial philosophy, generally speaking? Would you approach a hypothetical situation such, that what your ethics would be at odds with what maybe the law says? Questions of that nature. So I'm not sure we ask as maybe might be asked about judicial philosophy. The commission, and I want to be clear, we want the best 3 candidates for the governor to pick. It does not matter the judicial philosophy at that commission level. What matters is this person qualified to be a Supreme Court justice? And the 3 justices that I have been a part of, 2 of them, one of them came from private practice, Justice Jarash, and one of them came from the bench, Judge Fenn, Justice Fenn, and then the third one was the former Attorney General of the state of Wyoming. And those three are extremely qualified individuals. So do we ask them specifically about specific judicial approaches? We probably do not, because it's a bigger question than that, in my mind, personally for me.
Very good.
I feel like the last woman standing.
No, I was saying bring us home.
Bring us home, all right.
All right. Well, good morning, or good afternoon now, I guess. My name is Jennifer McDowell. I'm an attorney and a shareholder at Wellborn Sullivan McIntooley's Casper office. I've been practicing law for 22 years and licensed in Wyoming for 20. I'm also a proud Casper native. So foremost, I want to thank you for taking the time to listen and to educate yourselves on any potential changes to Wyoming's current judicial selection and retention process. In an effort to avoid repetition and be succinct, I actually want to discuss the practical operational implications of adding Senate confirmation, even if it's only to the Wyoming Supreme Court and not to the rest of our judges, excuse me. As alluded to by Justice Davis, the decision to add Senate confirmation is going to impact a lot more than just the business of the Supreme Court. It will also impact the operations of our district courts and the resolution of all cases, as well as legislative operations. Now, we have currently 9 judicial districts that are spread over 23 counties. Last fiscal year, our district courts handled almost 13,000 cases, and our circuit courts handled 106,000 cases. District courts are our highest trial level courts. And I just want to correct something that was said earlier. All of our courts answer constitutional questions and consider them if the constitutional question is posed in front of them as part of the case. Now, as part of our trial court system, we have 27 sitting district court judges, at least 7 of whom must currently cover and travel to multiple counties as part of their ordinary judicial duties. Now, what these numbers mean is that our dockets are crowded, and having one unfilled judicial post has a significant impact on the speed and resolution of cases. If one judicial vacancy occurs, our citizens can expect litigation to move slower. Everything from your traffic tickets to your uncontested divorces to probates to restraining orders. Wyoming Supreme Court is our only appellate court. And as such, it must decide every case that comes before us. Excuse me, before them. I'm not a sitting Supreme Court justice, darn it. Our sitting Wyoming Supreme Court consists of 5 justices, and any case in front of the Supreme Court must be heard by at least 5 judges. And as you heard from Justice Davis, the district court judges fill in when a sitting Supreme Court justice cannot hear a case for any reason. So for example, if there is a conflict of interest. An extended delay in filling a Supreme Court vacancy will inevitably prolong the time for resolving any appellate matter, simply because of scheduling problems. Plus, there will be a trickle-down impact to the district court level because district court judges will be filling in to hear appellate court cases at the Supreme Court level, thereby prolonging resolution of cases in their own districts. According to the Wyoming Judicial Branch's Administrative Office, Under the current system, the system explained to you by Ms. O'Connell, it is a rare occurrence when a judicial post at any level is unfilled for any length of time. And when a vacancy has occurred in the past, it's typically been for a very short duration of 2 to 3 months. A Senate confirmation requirement will eliminate that efficient appointment of qualified judges. As someone else pointed out, and I apologize, I don't remember who it was, but our legislators are volunteers and sit in sessions for less than 2 months of the year. So what happens when a judge retires or is disabled or passes away and the Senate is out of session? What happens if the applicant chosen by the governor is not confirmed by the Senate and the process must start over? How long will our citizens have to wait for that position to be filled and thereby suffer the impacts of an unfulfilled judicial post? Now, I can't give you those answers, but what I can tell you is that under the current 90-day merit-based process, there were 3 Supreme Court appointments from January 1st, 2020 through today, and there were 6 Supreme Court appointments in the last 10 years. Meaning if this constitutional amendment had been in place in the last 10 years, the Senate's time would have been required for 6 different Supreme Court confirmations. And any of those confirmations could have been held up for any of a number of reasons, leaving the position vacant, and most importantly, leaving Wyoming without an appellate court. Finally, as Mr. Fuller pointed out, 2 hours ago, the current Senate confirmation statutes apply to executive positions, not judicial branch appointments. And as I understood what Mr. Fuller said, it is quite possible that when the governor's term expires, the entire sitting Supreme Court would also be leaving the bench. And that would grind our judicial system to a complete halt and leave our citizens of Wyoming entirely without an appellate system. Thank you for your time and consideration. I hope I was brief.
Appreciate it. Thank you. Questions? Okay. Do appreciate that. Anyone else in the room waiting to testify on this bill draft? Mr. Crenny, please be brief.
Thank you, Mr. Chairman. I will try to be brief, and I apologize in advance for failing. I'm not going to get into any of that, whether this is a good idea, bad idea. As a voter, I'm sorry, Joey Carenti testifying as a private citizen. The very end of page 3, where it just says, the person would be required to be confirmed by the Wyoming Senate before assuming office. It doesn't tell me anything about how that process works. Does that mean that we will have that vacancy until the legislature reconvenes? Are they going to be able to sit in there temporarily? They're not assuming they're in a interim position. I don't know. So I couldn't vote specifically based on the language that's missing. And that leads me into kind of my asymmetrical or peripheral concern. How it works, that's all going to get worked out. It's going to go on paper somewhere. The Wyoming voters are going to get to decide on it. But those questions need to be answered because I don't know. Are we calling special sessions every time we have a Supreme Court vacancy? And if we are, then what is the House doing while the Senate's doing that work? If we're waiting for the session, statute says that all that work and those appointments need to be done in the first 2 weeks, which means you're going to see a lot of Senate files that may not be able to get through committee because those committees are doing, and I get it, Supreme Court replacements don't come up all that often, but when this was originally pitched, it was all judges. So how long before, okay, we got through the first one, we changed the Constitution, we're doing this now, and now we know that we can go ahead and get all judges. And I'm not saying any of that's bad. I'm not saying the legislature wouldn't properly contemplate that, give the people the opportunity to discuss and then vote on it. My concern is protecting what was brought up earlier, the fact that we are a citizen legislature. And over the next 10, 15, 20 years, if these things progress, are we protecting the part-time, full-time job that you all do in maintaining a citizen legislature? So while the vehicle's being built, everybody's tinkering with the engine and the transmission, I'm looking at the brakes, I'm looking at the seatbelts. What language needs to be added or recognized in 2812-101 that says how this is actually going to work with Supreme Court justices? And then, although none of you can predict what future legislative bodies will do, where are the sideboards making sure that we're not continually running into situations that we either have to go without a function of government or increase the legislative calendar? And with that, I will stand for any questions.
Thank you. Mr. Correndi, questions? Good points. Appreciate it. Anyone else? Seeing none, we're going to close public comment at 12:58. Right on time. Not, but very worthy discussion. Committee, what's your preference on the bill? Moved by Representative Lane. Is there a second? Representative Brady. Amendments.
Mr. Chairman.
Representative Lane, amendments?
Thank you, Mr. Chairman. I would like to ask for Mr. Fuller to be able to have a little bit of privilege with the language, but I would like for there to be a statutory amendment, not necessarily for the constitutional amendment, but within the statute, that it says a Senate judiciary is to oversee a provisional appointment until the Senate convenes the following year, and then the body shall vote by day 10 of the legislature.
That's amending which statute?
Sorry, I have it open. I just have to flip to it. Mr. Fuller, go ahead.
So, Mr. Chairman, I think there would need to be an amendment somewhere in 2812, 101 through 103. I'm not sure of the exact place. Mr. Chairman, one important note, that would have to be a separate bill draft. That could not be included in the text of this constitutional resolution. And then, Mr. Chairman, just one other item for the committee to consider. I understand the motion to be, and I'd ask Representative Lean to correct me if I'm wrong, the Senate Judiciary Committee would vote, and I think, Mr. Chairman, one consideration for the committee is the legislative power being vested in the House and the Senate. That's what the Constitution says, and whether a committee could take an action independently of the Senate as a whole.
Mr. Chairman, that sounds like an entirely different discussion than we've started with today. Could I ask for that bill draft to be drafted and then have those conversations on our way to our next
You can,
meeting?
but not at this moment. Right
Okay.
now, we're at the resolution that's before us.
Okay. Mr. Chairman, I respectfully withdraw my motion to amend.
Okay. So any amendments to the resolution that's before us? Okay. Call the roll.
Sponsor the bill.
Does the committee sponsor the bill? Discussion separate from amendments? Representative Kelly.
Thank you. Really quickly, remember, we're not deciding here if we're going to make this change. We're not arguing if this is a good idea or not. We've heard a lot of stuff from voters. I've heard nothing from out of state. We've heard a lot of pushback from people within the system. We need to determine if it's just a noisy minority or if this is really a groundswell. The only way to do that is to actually send it to the people and let them tell us.
Senator Hicks.
Discussion that we continue to need forward. I would be more than happy to explore rules and some alternatives in lieu of trying to propose a constitution amendment. But if we don't have this vehicle now, that discussion will not take place. And so for the time being, I'm going to support this motion to move this forward. And maybe we can have some further discussions at our next meeting. And so, Mr. Chairman, I'll be voting aye and moving this draft constitutional amendment forward. And that's my rationale.
Further discussion? Senator Kolb.
Yeah, thank you, Mr. Chairman. Yeah, and I'm of much of the same mind. I think there's some things we have to work on, but I think it deserves further discussion, and I'll vote aye also. Thank you.
Further discussion? Okay. I'm going to be a no vote. I just think that the practical realities of trying to make this work in the citizen legislature is just so impractical that it's not going to happen, and without great disruption to the appellate process. So I think that there is an opportunity. I think the judicial branch has expressed some interest in doing what they can to make this process more transparent without scaring away half of your applicants. So I think that progress can be made even without this bill surviving today, and so I'll be a no vote. Further discussion? The question being called, call the roll, please, Clarissa.
Mr. Chairman, this is a roll call vote for 26 LSO 77, Wyoming Supreme Court Justices, Senate confirmation. Senator Crago? Senator Crum?
No.
Senator Hicks? Senator Kolb? Representative Brady?
Aye.
Representative Bratton?
Aye.
Representative Chestick?
No.
Representative Filer?
No.
Representative Kelly?
Aye.
Representative Lean?
Aye.
Representative Singh?
Aye.
Representative Webb?
Aye.
Co-Chairman Olson?
No.
Chairman Washit?
No.
Yep, Mr. Chairman, that vote fails by a vote of the Senate.
Failed by a vote of the Senate?
Yes, Mr. Chairman, I had 2 aye, 3 no for the Senate.
Okay. Do we still have a interest in a bill draft, Representative Lean?
No, Mr. Chairman, thank you.
All right. Well, that gets us through our 10:50 topic. We're way behind. I'm going to suggest that we take an hour for lunch. We'll be back here at 2:05. And we'll take up the Wyoming State Hospital at 2:05. And we'll stay as late as we need to tonight.
And Mr. Co-Chairman, Mr. Fuller, if we could reach out to the Attorney General to let him know that we're running behind. Yeah, that would be helpful. That would be great. Thanks.
We stand in recess.